So dear everyone, welcome to our first lecture on Module 5 on the law and economics of merger control. So for this session, we have the great honor to start with Nicolas Levi, who is partner at Cleary Gottlieb. He is one of the leading antitrust lawyers in Europe. So that's a lot. Nicolas has extensive experience in notifying merger and joint ventures under the EU merger regulation, coordinating the notification of international transactions and advising on all aspects of antitrust law, including anti-cartel enforcement, collaborative arrangements, vertical agreements, and unilateral conduct. Please do not hesitate to open your microphone if you have any question to Nick. This is something that I want to notify is that we will have a Q&A session at the final lecture on the 21st of January. So we will try to do a few breaks during this session. The lecture will finish around 6, if not nearly. Voila. So here it goes. Nick, the floor is yours. Enjoy your afternoon, everyone. And thank you for being there with us. Thank you.
So thank you very much, Valerie. Can everyone hear me okay? I think so. Excellent, excellent. I'm delighted to be teaching this course. I've been lucky enough to be doing this actually since the outset. I can't remember when it began, Valerie, but I recall the call I got from a couple of then young professors of the University of Liège who had this idea to set up this these series of courses, and it sounded exciting, it sounded interesting, and it's turned out to be a lot of fun. Every year I think it's going to be my last, either because I expire or because everyone gets fed up of hearing me, but here I am again, and it's a real pleasure. I'm sorry we're not together in person. Nothing would give me a greater pleasure than to be together with you all in the same room. That's how we were in the old days, and I very much hope that's how we will be in the future. I think the third session of this three-part module, the idea is to be in person. I'll talk a bit about that in a second, and then it will be a very nice chance to meet some of you. It's not compulsory, but if you want to have your screens on, do. It's nice for me to see you, but if you'd rather not, totally understand. I remember one of the early sessions when I was doing this, I took one of my kids along, and at the halfway point, I said, "How did you find it, Elliot? What did you think?" He said, "Oh, Dad, it was all right. It was quite interesting, I guess." And I said, "You know, I couldn't help noticing that you were texting a lot." And he rolled his eyes and said, "Dad," he said, "everybody was texting." So I totally understand if you have other things to do while this goes on. But I would also really encourage you to stay engaged if you can. And if you do have questions, please ask. As anyone who knows me for 5 minutes will say, 5 minutes is a lot of me, so 5 hours or whatever it is a huge amount of me. I would love to get questions, firstly because I like it, it provokes a dialogue, and it breaks things up from just hearing me and seeing me present slides. So welcome then to merger control. This has been my world for the past 30 years, which, looking at a number of the faces on camera, probably predates the time on which many of you were on this planet. I came to Brussels as a young lawyer in 1990. 1990 is an important date in the history of merger control in Europe, because as you'll hear, it was the year in which the European merger regulation came into effect. I didn't come to Brussels because of it. It turned out it was just happening at the time that I did. It was a very zeitgeisty time in the development of the European project, no more so than in the competition area. When I began, the Brussels bar was still a relatively small bar, and I don't know how many competition practitioners there were in Europe, maybe 100. National competition law enforcement was in its infancy. And one of the things I'm going to try to do a little as we go through today is to convey some of the changes that have taken place. And standing back, one of the most significant changes has really been just the exponential growth in competition law enforcement in Europe, and also in turn the growth of the competition bar that I'm a part of. So back to 1990, I was obviously a lot younger. It was a time when, as I said, the competition bar was a much smaller place. And the focus of practice until then had been largely on Articles 101 and 102. And I'll talk just a little about that when I get into the introduction of today's session. I remember the mixture of excitement and curiosity and trepidation that greeted the entry into force of the merger regulation. There were a lot of reasons for that, and I'll be talking about those as I go along. As Valerie said, this has been a core part of my practice throughout my entire career. It's an area of law that quickly established itself as being a very important one. You'll all be thinking about your own careers, I'm sure, and this is not a sales talk about why you should practice in the merger field, still less why you should do so at Cleary Gottlieb. But suffice to say that it's a really, really interesting area of practice that is extremely suitable for young lawyers that are interested in some of the features of the practice. And as I think of the features of the practice, and I'll be trying to communicate some of those as we go along, it's extremely fact-based, probably more so than 101 and 102, certainly 102, which is often, at least among the three main pillars, I think it's the pillar that most frequently raises challenging legal issues. 101 does too, but principally, I think, with respect to the analysis of vertical arrangements, I think the cartel practice, which is a big part of the 101 area, it shares with merger control a facts-based feature. So for those of you who are curious about the world, interested in how companies operate and compete with each other, it's an extremely interesting area. And allied to that is perhaps a second feature. There's an awful lot of economics in merger control. The second module is going to be given entirely by an economist. Just as the legal bar has grown over 30 years, a bar of specialist economists who support lawyers in advising companies on transactions they're contemplating and in trying to get those transactions approved has grown up. So if you're interested in economics, the application of economics to the law, this is an extremely interesting area. Thirdly, it's fast moving. As you'll hear, there's a prescribed timetable for the assessment and investigation of mergers that are subject to pre-closing review by the European Commission and indeed by national competition authorities. And that makes the practice intense and I think exciting. It's not to say that 101 and 102 areas are not intense or exciting, but cases can often go over a longer period of time, and the stakes may still be very high, but you don't necessarily have within such a concentrated period the same experience. Fourthly, merger control often involves matters that have extremely high profiles. Not only high profiles in the sense that you read about them in the newspapers, but for very many of our clients, you have the attention of the CEO and of the board. Oftentimes, they will follow cases extremely closely. The careers of individuals can be affected by the outcome of cases. I think probably the record I can think of in this respect, I remember a case I did ended unsuccessfully, unfortunately, but we had, I think, 25 board meetings over a period of 18 months to discuss the transaction and for the board to quiz lawyers on progress and take a view as to whether remedies should be offered, for example, to address concerns, or whether alternative transactions should be considered. Fifth element, and this is one that's evolved over time, is the international, the global nature of merger control. As you'll see, when the merger regulation came into being, when I started work, there were really only 5 or 6 jurisdictions around the world that had a developed system of merger control. And now pretty much every country with a flag has a system of merger control. And I'll show some slides later on to illustrate the extent to which transactions that are being reviewed in Brussels are also now increasingly being reviewed by 10 or 15 or 20 or 30 different agencies around the world. And if that's an aspect to professional activity that interests or engages you, then this is a good area to get involved in. And the final feature of the practice that I draw out is that it's challenging, and it's challenging for a number of reasons, some that I've spoken about. It requires the marshalling of an awful lot of factual and economic and empirical evidence, and the application or the analysis of those facts within a legal framework. It involves the development of a strategy designed to secure the best possible outcome for your client, that necessitates you as a lawyer working with business people to understand the facts, with economists to understand what the best economic evidence may be, with government affairs advisors to craft the best media strategy or the best government affairs strategy, with senior management to advise them on the likelihood of success, sometimes with other law firms, your co-counsel or lawyers on the opposing side of the table, if you like. It involves presenting a transaction as a matter of advocacy, firstly in writing, secondly in the form of meetings, thirdly sometimes before the commissioner or in hearings, and sometimes even before the European courts if matters go to appeal. And all of those different aspects to a case require different but complementary skill sets. And so one of the things that I enjoy most about this area of practice is that it really tests you in a wide variety of ways. So what I'll try to do in the time we have today is to provide some grounding as to the principal pillars of the law. And I'll speak in a second or two about exactly what we're going to do this afternoon. I'm also going to try to communicate and pass on some practical advice. I've peppered the presentation with some case studies and some examples of evidence I've presented in cases I've been involved in. I don't have a monopoly on this area of the practice. There's heaps and heaps of other really interesting cases out there, but the ones I know best, like many lawyers, are the ones I've been involved in. So the examples you're going to get broadly coincide with cases that I know, but please don't view that universe as being the universe of interesting cases that you should know about. And as I've said, I will try to address your questions. I think there's a hands up feature, or if there's not, just like talk over me. And some of my colleagues will know I'm not embarrassed if you talk over me. I won't be necessarily shy to talk over you. So don't hesitate, just pipe up if you have a question. So those are the introductory remarks. I'm going to share my screen. You tell me if it works. Does it work? Everyone, somebody, yeah, nod or something.
Yes, perfectly.
Excellent, excellent. Right, so let's get going. Just to manage expectations as you're here, there are 4 decks. Hang on a second. 4 decks today. So the first deck, overview and introduction. I'm going to talk a little about the historic background to the merger regulation, and then introduce you to the principal legal instruments, the tools that you need as a practitioner if you're working in this area. I'll then say a word or two about the objectives of merger control. And until about a year or two, actually, this was a fairly easy topic to deal with. It's become a somewhat more complicated topic because there's a very active and engaged debate going on about whether the objectives of merger control, as they've been historically framed, are appropriate. Are they too broad? Are they too narrow? So I probably should have said at the beginning, to my mind, this has always been an interesting area of the law to practice in, but it's an especially interesting time to be practicing or to be interested in this area of the law, because there's a lot of debate going on as to whether the rules that have been established over 20, 30 years are correctly framed. So I will spend more time maybe than I've done in the past talking a little about that. I'm going to say a word or two about the Commission's enforcement practice historically, and then introduce you to some of the issues that have arisen in the past and arise today, some relating to the jurisdictional scope of merger control, which sounds a bit dry, and I suppose is, but actually has some pretty interesting aspects to it, because they go to one of the most hotly debated questions at the moment, which is whether merger control is sufficiently broadly scoped in its jurisdictional ambit to capture all transactions that may raise competition concerns. There's also a series of discussions going on about substantive issues in respect of EU merger control, and I'll talk about that. And then I've trailed this already, I'll talk about the globalization of EU merger control. Then we will take a break, and then I'm going to introduce you really to what is the core of our practice. So the theories of harm that agencies routinely apply when analyzing a particular transaction. How do they endeavor to distinguish between the benign and the malign transactions? What are the theories of harm that they look at? Merger control, unlike Articles 101 and 102, which look up the past, has there been an anti-competitive agreement or understanding? Has there been an abuse of a dominant position? Merger control is predictive. It looks into the future. So evidence is important. Evidence of the past can be critical to reaching an informed view of whether a given transaction is likely to be benign or malign. And when I said at the beginning, a lot of our time and energy is consumed with looking at the facts, it's really looking at the evidence. And the kinds of evidence that are looked at have evolved over time. The amount of time that agencies spend analyzing and weighing evidence has changed over time and become more sophisticated and more demanding of the process and indeed of practitioners. I'm going to talk a bit about the use of evidence, and then I'm going to give you some case studies, and these are drawn from cases I've been involved in. I'm going to present slides from about 10 different cases I've been involved in that will hopefully bring to life a bit the way in which we as lawyers think about particular cases, particular markets, the analysis of them, and make some of the theories of harm that I've talked about and some of the topics you'll be hearing about next week from Miguel de la Mano more accessible. We will then take another break. And the final two sessions, which I'll do relatively quickly, partly because they're not as interesting if I'm being candid, and also because they are, I think, pretty thoroughly covered in the slides and also in Commission notices that I will mention. Firstly, I'm going to talk about the jurisdictional scope of the EU merger regulation, what kinds of transactions, concentrations, is the term of art the Commission uses for transactions that are subject to merger control. what type of concentrations are caught by the EU merger regulation and what type of concentrations are not caught. And I will then talk about the division of powers. What does that mean? It's the separation of jurisdiction as between the European Commission on the one hand and the member states on the other hand. And I'll describe briefly the mechanisms that exist to transfer jurisdiction either from the member states to the European Commission or from the European Commission to the member states. And at the end of that, I think you will have had enough. So that's what we're going to cover this afternoon. Foretaste of what you're going to hear next week from Miguel de la Mano. He's going to provide an economic overview of what is the core of merger review, the substantive assessment of concentrations, introduce you to market definition, the competitive assessment of transactions, and the main theories of harm. So this is the first slide, which you're going to see the four main theories of harm that I'll talk about a little later. Unilateral effects, coordinated effects, vertical effects, conglomerate effects. Don't worry if you don't understand what those are just yet. I'll be talking about them a little later. And then the third session in 2 weeks' time, we divide into two parts, really. The first part will be presentations on three topics by my partner, Chris Cook. He's going to discuss procedural issues, which may sound dull, but is not at all. So what's the procedural process that has been established for the review of transactions? What are the key elements in that process? He'll take you through those and share some war stories from cases as to some of the procedural issues that arise in merger control. He'll also talk about remedies. So the possibility exists, as you'll hear, if an agency identifies a competition problem with a transaction, you as a counsel to the merging parties have the possibility to offer remedies to secure approval, to address the concern that's been identified. And this has evolved as an important, almost standalone area of practice. And Chris will talk to you about that. And finally, we'll talk about judicial review. So any decision that's taken by the European Commission under the merger regulation, and there are about 30 different types of decision that the European Commission may take. Any one of those decisions can be appealed to the General Court and then the European Court of Justice in Luxembourg. And Chris will be talking about the principles that exist for judicial review. And Chris will be joined by a former colleague of ours, a fellow called Michele Piergiovanni. Michele is one of Commissioner Vestager's principal advisors. She has a private office called Cabinet, and Michele is the number 2 figure in that private office, and he advises her on merger control. So he's an important figure in our world. And Chris and I, assuming the technology works, will have a Q&A with Michele, to which you are very much invited to think of questions as well. We will ask him questions about a whole range of topics. So that's how we're going to finish the series of 3. So let's get going with historical background. So in the beginning, in 1957, which was before even I was born, the Treaty of Rome, the founding document of what is now the European Union, contained no merger control rules. That created an enforcement gap between what are now Articles 101 and 102. So as I'm sure most of you know on this course, Article 101 is concerned with agreements or understandings, whether they be horizontal or vertical, between independent companies. So bilateral, trilateral, or multilateral agreements between independent companies that have an anti-competitive effect. So that's Article 101. Article 102 prohibits abusive conduct by dominant companies. So just as in Highlander, there can only be one. There can only be one company generally in any market that is considered to have market power. Companies that have market power and are dominant have a special responsibility to maintain competition. And over time, the Commission has identified a series of types of conduct that can infringe Article 102. So both of these pillars of antitrust enforcement share some elements. The first is that they require conduct to have already occurred. And that is an important feature of both 101 and 102. So they don't prevent the creation of a dominant position in respect of 102, for example. They generally aren't used to create a more competitive structure of the market under 101. They look at past conduct, and that created a gap in the framework of European law, because there was no possibility under the Treaty of Rome to investigate, still less prohibit, transactions that might in fact have an anti-competitive effect, including because they might create or strengthen a dominant position. There were some attempts to apply 101 and 102 to concentrations. Under 102, so you recall, that concerns the abuse of a dominant position. There was the leading case in this respect was a case involving a company called Continental Can that held a dominant position in the production of metal containers used for meat and meat products and fish. I'm already introducing you to the question that we'll be talking about in more detail as we go along. How do you define the market? But in this case, the market was defined as the market for light metal containers for meat products, fish and crustaceans. The Continental Can had a 70 to 90% share of that market and a somewhat lower share of the market for metal closures for glass jars. And it acquired a controlling shareholding in one of its competitors, and the Commission found that transaction was abusive under 102. And that decision of the Commission was upheld by the Court of Justice, which determined that abuse may occur if an undertaking in a dominant position strengthens such a position in a way that the degree of dominance reached substantially fetters competition. So there was precedent to apply 102 to a transaction. There was also precedent to apply 101. The leading case here involved two cigarette producers. Philip Morris was not in a dominant position, so that 102 wasn't triggered, but it acquired a shareholding in one of its leading competitors, Rembrandt, and that in turn owned a company called cigarette brand called Rothmans. It was a fairly concentrated market even then, and the Commission was concerned that the acquisition of this shareholding, together with the rights that Philip Morris had on the board of Rembrandt, would confer influence over Rothman's conduct and would thereby reduce competition, and 101 was applicable. Again, that went to the Court of Justice, which upheld the European Commission's decision in this respect, that the acquisition by one company of an equity interest in a competitor doesn't in itself constitute conduct restricting competition, but it may serve as an instrument for influencing the commercial conduct of the companies. So there may be circumstances where there is a breach of the competition rules. Now, the use of 101 and 102, although it occurred in these cases, was not a very satisfactory tool for a number of reasons. Firstly, because as I've explained, the Commission can only apply these tools to transactions that have already occurred. And it's unsatisfactory to really wait for competition to be harmed by transactions. And secondly, the procedure that the Commission applies under 101 and 102 is quite a cumbersome one. It takes time, and during that time, of course, the injury resulting from the transaction may continue, and then the case may be appealed. So these are fairly blunt instruments to try to address concentrations. And so for a long period of time, there was a debate between the member states as to whether the Council, the political institution within the European framework, should adopt a merger regulation. And the first merger regulation, the first form of merger regulation, was proposed in 1973. There were 16 years then of negotiation before the European merger regulation was adopted in 1989. And as I said earlier, came into force in 1990. And there were a lot of issues that had to be determined during those negotiations, which I'll talk about in a second, but they related to the geographic scope, the jurisdictional scope, what transactions should be caught by the merger regulation, what should be left to the member states or to Articles 101 and 102 to consider, what the substantive test should be, whether there should be the possibility to exempt mergers that were found to be anti-competitive, should remedies be acceptable, should the procedure be subject to time limits, should there be the possibility for judicial review. And all of these questions were thrashed out over these 16 years. But even when the merger regulation came into being in 1990, there was still an awful lot of open questions, including about the European Commission's ability to actually apply successfully the regulation itself. And I'll try to give you a sense of some of those issues as we go along. So when we talk about the merger regulation, we think of this area of practice. What are the legal instruments that we're concerned about, and what are the key features of the regulation? So the key features, I've reduced them to 6 here. First feature of the law, and this reflects some of the decisions that were made, it is a mandatory system. So that means if you enter into a transaction that meets the requisite criteria, you have to notify that transaction. You don't have an option, as you do in some countries like my own, the UK. We have a voluntary system of merger control. The European one is a mandatory one. It applies to acquisitions of control. And the penultimate session today, we talk about what does control under the merger regulation mean, and applies only with respect to transactions involving the acquisition of control that meet certain revenue-based thresholds. And so there's been debates over time about the definition of control, but also about whether revenue-based thresholds are the best way to establish jurisdiction. There are other ways jurisdiction could be established. In the US, they have a test that are also based on asset value. The UK has a system based in part on market shares, and other systems around the world have hybrid systems too. A second feature of the merger regulation, which I've alluded to earlier on, is that there's a division of powers between the European Commission and national competition authorities. So transactions that are subject to review by the European Commission, that excludes review at the national level, and similarly transactions that are subject to review at the national level, the European Commission is not permitted to review those transactions although as you'll hear in the final session today, there is the possibility for national agencies to refer transactions to Brussels and Brussels to refer transactions to national agencies. The third election that was made is that the system should be administrative. Now, broadly speaking, there are two systems that are applied by agencies around the world. One is an administrative system where an antitrust agency, an independent agency generally, investigates, prosecutes, and decides a case. Another is a judicial system, and the leading jurisdiction in the world that has a judicial system is the United States. And I'll talk a little about the debate that's gone on as to the pros and cons of an administrative system versus a judicial system. But the European system, and it's one that's been followed in every country around Europe, is an administrative one that gives great power to the European Commission. So in addition to having a mandatory system and one in which companies whose transactions meet the thresholds, not only do they have to notify, but they cannot close their transactions until they get an approval decision from the European Commission. The Commission elected to have a front-loaded notification system. What do I mean by that? I mean that the procedural rules that were developed by the Council require companies, when they notify a transaction to Brussels, to provide a great deal of information. So a notification is not just a 2 or 3 page form as it is in the United States. It is a filing offering that often now runs into hundreds of pages long, analyzing the effective markets, providing extensive market share information, often providing internal documents, sometimes substantiated by economic evidence. A great deal of our time as practitioners in this area is often spent preparing that, that notification and then in nursing a transaction through the European Commission, engaging with the staff that review a transaction in order to persuade them of your case. Fifth feature of the merger regulation is its transparency. The European Commission publishes a reasoned decision at the end of every case. Some of them are very short, in some cases simplified cases that don't involve any issue. The Commission has taken to publishing one-page approval decisions, but in every case that raises any kind of issue, the Commission publishes a reasoned decision, some of them spanning hundreds of pages of text. So if you go to the DG Comp website and into the merger site of that website, you can read all of the Commission decisions. There are over 8,000 of them over the last 30 years. You can read all of those decisions. And it's one of the reasons, I think, why very many emerging market jurisdictions have adopted systems of merger control quite similar to the European one. Firstly, I think they retracted to an administrative system. Secondly, it was seen to be a system that was working quite well. And thirdly, there was a lot of available precedent, which I think it was helpful to countries that were setting up their own systems to be able to review and to call on. And the final key feature of the EU merger regulation is the right of appeal to the European courts in Luxembourg. So while in the United States, as I mentioned, they have a judicial system. So there you have 2 independent agencies, the Department of Justice, the Federal Trade Commission. Officials in those agencies investigate cases and can approve transactions, but if they want to prohibit a deal or believe a deal should be prohibited, they have to go to an independent judge and persuade that judge to enjoin a transaction. Our system is a different one. The European Commission investigates and decides, but then you have a right of appeal to the court in Luxembourg. So here's the law. This is an introduction to the principal legal instruments that we as lawyers have access to. And one of the decisions the Commission made early on, which I think was a very smart decision, was to try to inject as much transparency into the practice as possible. So compared, for example, with Articles 101 and 102, where the Commission publishes a decision in respect of every infringement cases, but now for 10 or 15 years is no longer in the practice of publishing decisions when it approves particular forms of conduct, doesn't have to provide guidance as to its current thinking on particular kinds of conduct, although it's adopted block exemptions and the like. The merger regulation, it's very rich in legal text. The principal legal instrument is the merger regulation itself, and its sister regulation, the implementing regulation, which contains and sets out the procedural rules. And they establish a whole lot of principles relevant to jurisdictional scope, the substantive test, the rights of appeal, contain deadlines for notification, and so on and so forth. Commission has also adopted a number of notices which codify its decision, are very useful as a practitioner to be able to look at one of the notices or one of the sets of guidelines to understand the Commission's approach to particular issues. There are 5 main notices, one concerning jurisdiction, explaining how the Commission has approached the definition of concentration or the allocation of turnover, those sorts of questions. Second relates to market definition, how the Commission defines markets. Third relates to remedies, as I mentioned, the possibility to remedy competition concerns that are identified. And then there are a couple of notices relating to the cases that are relevant for the simplified procedure and what's called ancillary restraints, which are restrictions that companies to mergers agree that are directly related to the transaction and are therefore treated as ancillary and not subject independently to Articles 101 and 102. The Commission's also published a series of guidelines that provide counsel and companies with guidance on how they approach horizontal mergers, those are mergers between competitors, and non-horizontal mergers. So those are mergers that do not take place between companies that compete with each other, but companies that are in typically neighboring markets or where there's a vertical relationship between them, where one company is a manufacturer, let's say, and the other is a distributor. And the Commission's also published guidelines on the best practices in cases and the best use of economic evidence. As I've said, there are around 8,000 Commission decisions that you can review. And one of the first things one does when confronted with any new case in a market that one's not familiar with is to look at the approach that the Commission has adopted in that market or in a closely related market. And the availability of this jurisprudence is extremely helpful in that respect. It's not to say that markets can't change or the way in which an agency analyzes a situation can't change, but generally precedent is a very sound port of first call when you're looking at a particular case. And finally, their judgments of the court. The court has played an extremely important role in the merger regulation. And I'll say a word or two about that later on, and you'll hear more about it in the final session in 2 weeks' time. But the judgment of the court have really shaped the way in which the Commission handles the application of the regulation in some important ways. Who are the main actors in the application of the merger regulation? So unlike in the US, where the agencies must persuade a court to enjoin a merger from being completed, Our system, as I've said, is administrative. The Commission investigates, evaluates, prosecutes, and prohibits. And in the early days, commissioners other than the competition commissioners played an influential role. In recent years, though, cases have become more complex and fact-intensive. Decisions are effectively taken by the Directorate General for Competition. So as I'm sure most of you know, the European Commission is divided between a large number of Directorate Generals, ranging from environment, financial services, to taxation, and so forth. The Directorate General that we, as competition lawyers, spend almost all our time interacting with is the Director General for Competition, DG Comp. The principal decision makers in our world are the European commissioners. And over the lifetime of the merger regulation, there have been 6 commissioners. Leon Britton, who is a British commissioner, was the commissioner when the merger regulation came into force, succeeded by a Belgian commissioner, Karel van Meert, then by Mario Monti, who went on to become Prime Minister of Italy, Nelly Cruz, who was Dutch, Joaquin Almunia, who's Spanish, and the current commissioner, Margrethe Vestager, many of you know, is Danish, is the only competition commissioner to have been reappointed to that post. Typically, competition commissioners spend only 1 term and then either leave the commission or move on. She was reappointed, and she also has responsibility for the commission's digital agenda, which takes up a great deal of her time. In high-profile cases or cases where it's uncertain the commission is going to approve a transaction, one may have direct access to the commissioner as a decision maker, but by and large, the people that we deal with are the officials within DG Comp. This is the DG Comp organogram, headed by the Director General, is a Frenchman, Olivier Garçon, and it's divided by subject area and then by types of industry. And so there's a head of mergers, the top left-hand column. Frenchman Guillaume Loriot is the current head of mergers within the European Commission, and he has a team that advises him on a whole variety of issues, and will ultimately take cases to the commissioner. Our principal, the principal people that we interface with are officials who work in the units that are circled at the bottom of the chart. So the Directorate General for Competition is organized by industrial sector, chemical sector, or telecoms, or what have you. And within each of these sectors, there will be a unit that focuses on mergers. So if you have a transaction, let's say in the pharmaceutical sector, your transaction is likely to be reviewed by individuals who have expertise in pharmaceutical mergers, including to give consistency to the case. And they will often be the principal determinants of whether the Commission, at least in the first instance, identifies concerns with any transactions. There are also economists within the Commission. There's a chief economist team within the Commission that plays a role, and the Commission has its own legal service that will play a role in ensuring that any decision that the Commission takes is consistent with the law and hopefully won't get overturned on appeal. So what are the objectives of the EU merger regulation? Principal objectives are to identify and prohibit mergers that stifle competition. They will be stopped, all others will proceed. Those were the words of the first competition commissioner who applied the merger regulation, Leon Britton. Over time, it became very well established that in deciding or in differentiating between benign mergers and malign mergers, the Commission should principally have regard to consumer welfare. should be concerned about the interests of consumers, shouldn't be unduly concerned about whether competitors might be harmed by transactions or by whether employment should be affected or industrial policy objectives should be pursued, but whether consumer welfare. And there's a school of thought that developed in the United States, and one of the principal proponents of that, advocates of it, was a leading jurist, Robert Bork, whose learnings have become somewhat controversial in recent years, but he was very much a proponent of the view that consumer welfare is the only legitimate goal of antitrust. Antitrust shouldn't be about anything other than protecting the interests of consumers. And I mentioned earlier on that there are a lot of interesting debates going on at the moment. One of those debates is exactly on that topic, and I'll say a word about that in a moment. The merger regulation includes in its recitals 2 or 3 that set out its principal objectives. First being the completion of the internal market, and therefore the architects of the regulation recognize that mergers can actually help facilitate the internal market by bringing together companies in different parts of the community in a way that increases trade between countries and improves the competitiveness of the European industry. But nonetheless, some mergers can cause lasting damage to competition. And the decision, the substantive test when the merger regulation was introduced was gave the Commission the power to block transactions that strengthened or created a dominant position. There was a debate about 10 years or 15 years ago or now about whether that was the right test. I'll talk about that in a second. But the substantive test under the merger regulation today is that the Commission may intervene in respect of concentrations that may significantly impede effective competition. So the SIEC test, as it's called, significant impediment to effective competition in the common market, including by the creation, strengthening position. So let me say a word or two about enforcement practice, just to introduce you to some of the key pieces of data, if you like. What have we seen over the 30 years that the merger regulation has been in force? We've seen the Commission develop a more structured analytical framework. And this has manifested itself in a number of ways. I think most obviously in clear guidelines that enable practitioners to more predictably determine the kinds of transactions that are likely to raise competition concerns. The second theme or principal change is a more consistent focus on unilateral effects, and I'll talk about that after the break, following the adoption in 2004 of the SIEC test, the significant impediment to effective competition test. The third theme that you see in the evolution of the practice is more and better evidence. Commission investigations have become far more fact-intensive, more reliant on objective and quantifiable evidence. And this is in part a function of the standard to which the court has determined the Commission must base its decisions. The Commission bears the burden in merger review, both when it prohibits transactions and when it approves decisions, and it is required under the court's rules, under the system of law that we have, to reason its decision and to adduce clear and consistent evidence. And so one of the things that you see over time is Commission decisions have become much longer, much more fact intense, and Commission investigations have become much longer. So we see more economics and more economists being involved in merger review, and we see longer investigative review periods. More time is needed to gather and review detailed data. So let's have a look at some facts and figures. Over time, particularly in the first decade, you saw a significant increase in the number of transactions that the Commission was reviewing, from 60 in 1991, the first full year of the merger regulation, to about somewhere between 250 and 300 decisions at the end of the first decade of the merger regulations application. And since then, the number of transactions subject to Commission review has remained around 300 to 400. That sounds a lot. Very many of those, as you'll see, are simplified cases, often involving private equity companies or companies that are not competitors of each other, and the Commission has developed procedures to deal with those cases quite quickly. But the length of Commission decisions, as I said, has gotten a lot longer. This is in large part as a function of the standard that the court has held the Commission to. So the first phase 2 case, you'll hear about the 2 phases of the Commission's review process a little later. The first phase 2 case, and the first case subject to in-depth review in 1991, Commission decision in that case was 7 pages long. In 2020, the longest phase 2 case was almost 700 pages long. And I think the longest one the Commission's ever taken has been almost 1,000 pages long. So these cases are extremely detailed. A great deal of evidence is being adduced and analysed. And as a result, the length of time that the Commission takes to process cases has gotten longer. When I started practice, you had to notify a transaction within a week of announcement, and the Commission then had a month to take a decision. Those deadlines have been loosened up, and the practice of what's called pre-notification has developed that involves the Commission effectively investigating a transaction prior to the formal notification actually taking place. Has extended the review period. And this shows, this chart shows that in the early years of 2000, when this chart begins, so 10 years into the merger regulation, generally it was taking about 50 days for the Commission to take a decision in a case following announcement. In a phase 1 case, a relatively straightforward case, that time was 143 days. So that's a far longer period. Even in a straightforward case, the Commission's taking a lot longer to process more complex cases. Still processing the simplified cases quite quickly, but the more complex cases are taking longer. In cases that go to phase 2, that in the early days were being approved within a few months, at most maybe 5 to 6 months, they're now taking over a year to get approved. So the process of getting the Commission to approve complex transactions has really become a much more time-intensive one, much more exacting one over the period of practice. Most transactions are approved. Of the roughly 8,000 transactions reviewed over the past 30 years, 90-odd% of them have been approved unconditionally. Around 6% have been subject to conditions, to remedies, principally divestitures of assets, although there are some cases where behavioral remedies have been accepted. Small number of transactions, only around 50, the Commission determined it didn't have jurisdiction over those transactions. So the transactions were not subject to the European merger regulation. Those were mostly cases in the early years when there was uncertainty about the jurisdictional scope of the merger regulation. And the Commission has prohibited around 30 deals and a smaller number of cases. Companies have abandoned cases to avoid the Commission prohibition decision. So those are the 30 cases that have been prohibited. It's roughly one case a year. It doesn't sound very many. So, you've been hearing about this great industry that's been created to analyze these 8,000 transactions, about notifications running into hundreds of cases, and at the end of it, only 30 cases are being prohibited. I think the Commission would say in response to things, well, yes, that's true, but roughly 500 cases are being subject to remedies, and in some cases the remedies may, in some markets, amount effectively to a prohibition. And then there are many transactions that, if you didn't have merger control, might have been entered into, but the knowledge that the Commission may investigate and challenge chills companies from entering into mergers. This chart identifies those 30 cases, and it also highlights those cases which were subject to appeal and where the court overturned the Commission's prohibition decision. And there are quite a number of those cases, really, at least statistically. So you have 30 prohibition decisions, of which 6, so that's a fifth of those cases, have been reversed on appeal. In fact, actually, this doesn't count. The Telefonica 02 case should also be identified as a case where the court overturned the Commission decision. And those prohibition decisions that have been overturned on appeal have led to some significant judgments of the European Court that have had significant bearing on which the Commission has applied its rules. If you look over the last few years, you see an increased number of transactions prohibited. So if you compare the record under Joachim Almunia, the last commissioner before Commissioner Vestager, he prohibited 6 transactions or oversaw 6 that were either blocked or were withdrawn. Commissioner Vestager has overseen 17 transactions that were blocked or withdrawn. Again, that sounds significantly more. Of course, as you've heard, her tenure has been longer. And if you look statistically, actually, at the number of cases that were being blocked, withdrawn, or conditionally approved over the 2 commissioners' tenures, the numbers are not that different. One of the interesting debates, as I said, that's going on at the moment is whether enforcement has been either too permissive or has been too harsh. And I'll talk about that in a second, but certainly there are a number of national competition authorities that over the last few years have been far more interventionist than the European Commission. The UK authority in particular is now one of the most interventionist agencies in the world, has prohibited more transactions in the last 4 years since the Brexit vote than in the previous history of the agency. Is prohibiting routinely now several transactions every year. So let's turn now, as I mentioned, to some of the historic issues that have arisen under the merger regulation. I'm going to identify 2, then I'm going to talk about some of the jurisdictional issues that have been the subject of debate in recent years, and then some of the substantive issues. So 2 of the issues historically that have been the subject of debate among the legal community. First is the Commission's role as investigator prosecutor, judge, and jury. And this front page from the Financial Times from 2002 concerns a series of judgments of the European Court over a relatively short period of time. If we go back to this chart, you see in the period in the early 2000s, you see 4 Commission decisions: Airtools, First Choice, WorldCom, Sprint, Schneider, Legrand, and Tetra Laval Seadel. Within a relatively short period of time, 4 Commission prohibition decisions were overturned by the court. And a 5th one, General Electric Honeywell, was partially overturned. It was a very controversial decision because the Commission prohibited what was largely a conglomerate merger, a merger between companies that were active in adjacent markets. I'll talk about that after the break. It's one of the examples that I give. But the Commission prohibited that very controversial case. And there was a lot of criticism at the time of the way in which the Commission was applying the merger regulation. And the series of judgments of the court led to a lot of soul searching on the part of the Commission as to whether it should change or adapt its rules to better insulate its decision from judicial review. And there was a debate as to whether it was appropriate or correct or the right system to have an administrative system. And some of the US officials at the time were quite critical of the Commission of the EU system and compared it unfavorably with the US system, where the investigating officials have to go to a court to persuade a court to enjoin a merger. And what was said at the time by some is that the investigating case teams were not subject to the same checks and balances. They were more susceptible to confirmation bias, to prosecutorial bias, and that the system had some inherent weaknesses because it didn't have the checks and balances that a judicial system had. And in response to those criticisms, the Commission instituted a number of changes. And what it sought to do effectively was to achieve, through a system of internal checks, the guarantees of a judicial system. And the main criticism, as I've said at the time, was that a relatively small group of Commission officials, without sufficient scrutiny from lawyers or economists or others, was effectively taking a view as to whether transactions were malign or benign. There were a number of inherent checks that already existed, the possibility of judicial review and decisions being exposed to critical scrutiny, the system that existed and still exists for decisions to prohibit transactions for commissioners. The Commission in the early 2000s supplemented those formal checks with a number of others. So they set up a chief economist team. They created the role of a hearing officer to allow procedural issues to be adjudicated in real time by an independent figure. They set up internal scrutiny panels to subject the conclusions of investigating officials to more scrutiny. They came out with guidelines to ensure greater transparency, both as to procedure and also to substantive issues. And they enlarged the teams, the investigating teams, to reduce the possibilities of a relatively small number of people effectively deciding whether a transaction should be approved or challenged. The system is not perfect, but I think it's widely viewed as functioning very much better than it did previously. And it's probably no coincidence that far fewer Commission decisions have been overturned by the courts in the years since the early 2000s than in that period between 2002, 2004. One of the other debates that was also resolved to some extent around that same time concerned the enforcement gap that was perceived to exist in the original substantive test under the merger regulation. So the original substantive test under the merger regulation was one based on the creational strengthening of dominance. And as a result of that test, the regulation could be applied only to transactions that created or strengthened a dominant position. It required the Commission to determine that the merging companies would be dominant after the transaction. And economists had always said that this was an imperfect test because there were other types of transactions that might still harm consumer welfare, have an adverse effect on competition, but didn't create a dominant position. They may still give rise to what's called unilateral effects, the possibility that firms acting alone might increase prices or reduce output or innovation, or coordinated effects where a relatively small of companies, a duopoly, might be in a position to raise prices or act anti-competitively by reducing output, but that in neither circumstance would a dominant position be created. And this gap was illustrated by, it's been illustrated actually in a number of cases in the telecoms sector, which are typically fairly concentrated sectors, where concerns have been identified in respect to transactions that haven't created dominant players, but have nonetheless reduced the number of players. So in this example, two Austrian mobile telephone companies, Hutchinson and Orange, the number 3 and the number 4 companies, came together. They reduced the number of players from 4 to 3, but the market share of the merged companies at 27% was actually smaller than the market shares of the 2 other players at 31 and 41%. But the Commission nonetheless identified concerns because competition between the merging companies was seen as important, and as a result, there was concern that prices were going to rise as a result of that loss of competition. So the Commission identified a unilateral effect arising from the transaction, notwithstanding the absence of the creation of a dominant position. So the 2 debates that I've chosen to highlight, one concerning the way in which mergers are investigated in Brussels by the European Commission, and the other involving the substantive test that is applied. So let's turn to some of the jurisdictional issues that have arisen, and I'm going to identify 4 here. You'll recall that I said earlier on, the merger regulation applies to the acquisition of control, and it is based on turnover-based thresholds. So the revenues of the companies concerned determines whether the Commission has jurisdiction. One of the debates that has been had is whether the merger regulations, whether the limitation in the jurisdictional scope to acquisitions of control is too narrow. And this issue arose in a case I was involved in that concerned 2 Irish airlines, Ryanair and Aer Lingus. And for many years, Ryanair was interested in acquiring its principal Irish rival, Aer Lingus. And it took a shareholding in Aer Lingus just shy of 30%, and then made a bid to acquire all of Aer Lingus. And the Commission prohibited the bid, but determined it didn't have jurisdiction to intervene in respect of the minority shareholding, because that minority shareholding did not confer control. Now, some national systems of merger control do capture the acquisition of non-controlling minority shareholdings, the German system and the UK system in particular. But the European merger regulation does not. And so Commissioner Almunia, who was the commissioner at the time, initiated a debate as to whether the regulation, the European regulation, should be changed to allow for the Commission to have jurisdiction over acquisition of non-controlling shareholdings. And for a variety of reasons, the Commission determined not to change the rules. As you'll see, a common theme of these debates is ultimately the Commission decides not to change the rules. One of the reasons the Commission decides not to change the rules is that there is a perception, or has been until recently, that there is enough merger control in Europe and globally, and where the Commission leads, agencies around the world follow. And if the Commission were to enlarge the jurisdictional scope, for example, to capture non-controlling minority shareholdings, then all sorts of other agencies around the world might follow suit, and that would lead to a further increase in merger control, which, as you'll see in a second, is already pretty extensive and pretty burdensome. More recently, the debate has been around whether the thresholds are sufficiently broad to capture all acquisitions of control that may raise competition concerns. And the Commission's been particularly concerned about acquisitions in the digital area and in the pharmaceutical area, where sometimes companies viewed as having dominant positions, say Facebook, or very strong incumbent positions in pharmaceutical markets, may acquire, often for very large sums of money, nascent competitors, companies with relatively low revenues, but which are viewed as having the possibility in time to become important competitors of them. Facebook's acquisition of WhatsApp and Instagram are examples given of transactions that didn't fall automatically under the European Commission's rules, but potentially raise competition issues and should have, some say, have been subject to automatic European review. As the case, transaction in the pharma area, acquisition by mine, AbbVie, of a company called Pharmacyclics, and the question is whether that transaction should have been subject to the merger regulations review. So Commissioner Vestager instituted a debate as to whether the turnover thresholds were appropriate, or whether value-based thresholds would be a better test. If you look at the Facebook example, so Facebook bought WhatsApp for, I think, 19 billion, and WhatsApp's turnover at the time was 19 million euro, so far, far below the European regulations thresholds. And some said if you had value-based thresholds, you'd capture deals like that. Others, like myself, said, and there's all sorts of articles, of course, you can read on this topic, said that all sounds good in principle, but value-based thresholds are very hard actually to apply, and there's a risk that this turns out to be sort of a sledgehammer to crack a nut, and you end up capturing and burdening already an overburdened system. Review. More recently, this debate has become even more intense, actually, because of the concern that the leading digital platforms, Google, Facebook, Microsoft, Amazon, and Apple, the Silicon Valley companies, have been buying up large number of smaller companies in what some have termed killer acquisitions, buying up smaller innovators, and that these transactions are not being caught by the merger regulation, and that even value-based thresholds, were they to be introduced, wouldn't capture these kind of deals. Here, actually, the Commission has taken some action It's somewhat controversial. It came out with a guidance paper in March of last year, and I'll be talking about that in the fourth and final session today. But essentially, the Commission has encouraged national competition authorities to refer transactions that they believe raise competition issues, but are not subject to either European rules or to national reviews, or to national thresholds to the European Commission, in order to ensure that these kind of deals are not escaping scrutiny. And there are also rules that are being developed for the digital space as part of the digital markets legislation that the Commission is considering, that would require the leading digital platforms to register acquisitions that they make, and thereby give the Commission to try to get jurisdiction to review those deals. The final thing I just want to mention here, this is not really a jurisdictional issue, it relates more to a kind of substantive concern. But there was a few years ago a debate as to whether in kind of analyzing transactions, the Commission should also be concerned about the incidence of common shareholdings. So situations in which merging companies and or their competitors shared common shareholders that might limit competition between them. So very exciting, all sorts of interesting debates about the jurisdictional scope of merger control. There are also some active debates going on about the substantive review of merger control. When I started these seminars, it was fairly well established, I think, that the consumer welfare standard was the appropriate standard for the review of concentrations. Over the last few years in particular, interestingly, beginning in the United States, an important school of thought that's become a mainstream school of thought following Joe Biden's election as president and his appointment, in particular, of Lina Khan to the Federal Trade Commission, holds that merger control has been too permissive, particularly in the United States. One can observe a correlation between increased concentration and higher corporate profits and less competition. Senator Elizabeth Warren in particular has been at the vanguard of those who said that merger control, particularly in the United States, ought to be more interventionist. And one of the leading economists, industrial economists in this field, Joe Stiglitz, also subscribes to that view. And that's a sea change in our world. Historically, the United States was critical of Europe for intervening too often, as you'll hear. But was far more tolerant in the US, and that's changed, and that's a big change in our world. But there's a debating continental Europe, at least in the last couple of years, that goes in the other direction. This is a came into being, and it's usually its principal proponents are usually politicians. The most recent incarnation of this debate occurred a couple of years ago in fallout to a transaction our firm was involved a prohibition of two producers of trains, Siemens and Alstom. The Commission prohibited that transaction, a German producer and a French producer. One of the objectives of that deal was to create a European champion. And politicians in France and Germany were quite critical of the Commission's decision, although the antitrust agencies in those countries were more supportive of the European Commission. But there was an attempt made a couple of years ago, I think it's died down more recently, to inject a political dimension into European merger control. The European Commission has fiercely defended its independence and has resisted political pressure from time to time to approve transactions. There's also, and I should say, in addition to the debates about merger control being too permissive, should it be politicized? And the third area of merger control rules able to address the digital sector, which relates both to the jurisdictional scope of the merger rules, but also to whether the substantive rules are appropriate. There's a debate going on as to whether more account should be taken, not only of industrial policy and employment concerns, which is what's said by those who think political consideration should be considered, but also some say account should be taken of environmental concerns and not just consumer welfare concerns. So those are some of the debates at the moment. Final section just before we take a break. I just wanted to say a word about the globalization of merger control. So as I've said, 30 years ago, when the regulation came into being, there were 5 agencies around the world with developed systems of merger control: Canada, the US, Germany, the European Union, and Japan. Japan didn't much enforce its rules, and the European Union, of course, didn't have merger control enforcement really to 1990. And now we have, as I've said, a world in which every country with a system of, every country with a flag virtually has a system of merger control. And this has led to a significant increase in activity. If you look at 2018, for example, there were over 7,000 notifications of different transactions around the world. Some agencies reviewing over 2,000 cases in the case of the US, around 1,000 cases in the case of Russia, but very many countries reviewing hundreds of cases. Now, many of these cases are the same transactions being subject to review by different agencies. And a couple of examples of cases we've been involved in: Holcim Lafarge, there were 20 countries that reviewed that transaction over 15 months. So an example of how merger control just takes a lot longer. And Siemens Alstom, around 30 jurisdictions reviewing this transaction, ultimately being blocked over almost 18 months. So I realize that's a lot to take in the hour and a half that we've been going. We're at the hour now. I suggest we take a 10-minute break, come back at 10 minutes past 3 Brussels time. And then for the second session, as I mentioned, I'm going to introduce you to the substantive appraisal of transactions. I'm going to give you some war stories from some cases. So let's break now, and we'll be back in about 10 minutes.
Yes, thank you.
So, welcome back. Can everyone hear me? Can somebody nod or someone?
Yes, we hear you well.
Okay, very good, very good. Let's just wait a second. Yes, okay, so 10 past. Hope everyone had a nice break. I don't know if anyone has any questions before we go on to the next session. I would like to, yes, hand has been raised. Please go ahead.
Hello, hi everyone. Or shall it be me, or
No, we can hear you. We can hear you loud and clear.
Okay. So season's greetings to everyone, and thank you for very interesting topics, Mr. Levi. I've got some. My name is Ekaterina. I'm from Georgia. I work for local communications regulator, the NRA. So my question is coming from the more sectoral perspectives. You were mentioning that telco sector is becoming more exposed due to the digital era, etc. And so my question is coming from whether this, whether the sectoral regulators' role, how is it embedded in overall competition regulation and legislative frameworks? Because I know there are different approaches. Mostly in European countries, there are separate regulators. There is a competition regulator, and there might be some sectoral regulators. In our cases, based on our law, competition constraints, so also including the ex post regulations, also are a part of the NRA's review. So from the EU perspective, or also from the historical perspective, if you could cover how those are how those were developed. This is my first question. And you were also, and there might be those details maybe further, but my question, and we also a lot of times have questions with regards what exactly is control, because if we go directly to the shareholder, whether their shareholders are changed or not, but there might be some other instruments like debt instruments, so that there might be control obtained through the different debt instruments, also through the indirect shareholders, and there might be the case very important related with data ownership. There might be very small company, but which is owning some very market strategic data, and in case of becoming another party having the control over this data, it might strengthen competition on market. So.
Okay, so let me have a go at those, maybe taking them in reverse order. So on strategic data, the Commission there's no specific provision in the merger regulation that allows the Commission to prohibit or take account of whether data might be strategic. Clearly, though, the acquisition of a company with strategic data could be a factor relevant to determining whether competition could be affected. There are, as I'm sure you know, an increasing number of systems that have been developed around the world now that govern foreign direct investment. And at least in the UK, the system that came into being at the beginning of this year requires the mandatory notification of acquisitions of companies, including certain companies anyway, including companies that may have strategic data in certain sectors. And there are some transactions where the Commission has taken account of the potential effect of a transaction on data. So the Google Fitbit. So when Google bought Fitbit, which is a kind of sports wearable, one of the issues in that case was the volume of data, the volume of Fitbit data that Google would have access to post-transaction, and whether any competition issue or any other issue could arise as a result of that. And if you look at that case, it's probably too much for just answering this question. The Commission's investigation, some might say, even went beyond the boundary of what was reasonable within a competition assessment in taking account of the relevance of data. So, second question on control, and I'll be talking about the definition of control, but in two words, control is the possibility to exercise decisive influence. It can occur at levels of shareholding below 50%. There are cases of shareholding sort of considerably below 50%, where the Commission has found that control exists de facto rather than de jure control often, either because the minority shareholding it translates to a majority of votes cast at shareholders' meetings, or because of governance rights. Those are typically the mechanisms that give owners of minority shareholdings control. As to sectoral regulators, so this, as you rightly said, is a situation that exists more at the national level, because the sectoral regulators by and large are national regulators. So I'll talk about the UK. Obviously, I realize the UK is not part of the EU anymore, but it's the system I know best, and I think it's fairly representative of other places. That there is a sectoral regulator for the water sector, or for the telecom sector, and so forth. And generally, they don't have any formal role in merger control. But there may be cases where the investigating agency in the UK, the CMA, might nonetheless have regard to what a national regulator in a particular sector may say, because they're viewed as having particular expertise. And the same is true at the European Commission level. There are cases where the European Commission has had regard to decisions or findings, or in some cases, actually, the circumstance that a national regulator may regulate certain kind of conduct allows the Commission to conclude that it doesn't have a competition concern with a particular form of conduct, because it would be inconsistent with national regulation. What you have at the European level is you have other directorate generals with expertise, let's say in the energy sector or financial services sector. And let's say in a case involving stock exchanges, the Directorate General for Financial Services might have a view about a particular transaction, or might have expertise that the Commission might want to call on, but they don't have any formal role. They don't have a seat at the table or the possibility to veto a Commission decision, except perhaps at the formal level of the Competition Commission. And again, they can't veto it, they could just express a view, but it would, I think, largely relate to the quality of the Commission's assessment rather than to the judgment that's being reached. So I hope that broadly answers your question. There are a lot of interesting topics within each of those questions, but probably in the interest of time, we should park that for another day and perhaps have an offline discussion if you'd like to.
Thank you very much.
Not at all. So let's turn to application and evidence. And for those who are sort of conscious of the passage of time, don't worry, I'm going to take my time on this set of slides, because I think they're more interesting than the final two, and the final two we can cover relatively quickly. As I say, some of you want to turn on your cameras, please do. It's always nice to see you. If you do want to ask a question as I go along, either cut in or use the chat function. I saw somebody did in the first session. Apologies, I only just saw that. But if you want to ask a question that way, please do. So let's talk about application and evidence, which really go to the heart of the substantive review of transactions. I'm going to be talking about the principal theories of harm that the Commission looks at when it's analysing transactions, the principles applied to the assessment of evidence, the use of evidence, and some case studies. So this, as I say, is really going to the heart of what antitrust assessment is in the field of merger control. What we spend most of our time doing, I wouldn't say all of our time, because as I said at the beginning, some part of what we do to a great extent may involve the law, may involve procedure, may involve strategic advice, but the bedrock of practice is the gathering, the evaluation, the sifting, the presentation of evidence. All right, I was getting distracted by the chat. Okay, and then I'm going to do some case studies. So, so the principal theories of harm. I'm going to take you through the principal theories of harm using some very stylized examples involving fruit, apples, in fact, principally. And I'm going to use these examples, again, as I say, stylized examples, to illustrate the main theories of harm. So the principal theory of harm that is analyzed in, if you look at the statistics, I think it's something like 70–80% of cases that get looked at with care involve horizontal overlap. And the main effect that a transaction involving horizontal competitors can have concerns unilateral effects. So the possibility of the merged companies post-transaction to raise prices or reduce output or to reduce innovation. So the effect is unilateral, it's arising from the conduct of the merging companies. And that may arise from the elimination of existing competition or the elimination of prospective future competition. In my example, you have 5 producers of apples. 2 of them have 25% share each. They merge, and post-transaction, they account for 50% of the market. And the concern will be, as a result of this combination, the competition between these merging companies is lost. And that's the unilateral effect. It's focusing on the competition that's being lost as a result of the transaction. So there's a significant impediment to competition. The second example involves, again, unilateral effects, but the elimination of potential competition. So here you have a new entrant, an innovator that's poised to come in into the Apple world, and it's acquired by, in this case, a company with a 55% market share. And the concern is that as a result of this acquisition, the competitive pressure that the new entrant might have imposed on the company with a 55% share would go away. And this is the most common theory of harm looked at, as I say, in the great majority of cases. Second principal theory concerns what's called coordinated effects. And this is a risk of tacit collusion. We all know what active collusion is, where companies engage in a cartel. Tacit collusion, the market conduct that you observe is comparable to that which you would observe if there were a cartel, if there were collusion, but results from tacit collusion rather than active collusion. And there is considered to be a risk of tacit collusion in certain kind of markets where the products are homogeneous, where there is transparency, where there are relatively few players. And in those kind of markets, reduced concentration can give rise to a heightened risk of tacit collusion. And there the focus is whether the merging companies and their principal rivals could together raise prices, reduce output, or lessen innovation. That's more likely to occur where one of the companies that's subject to the merger is an innovator or a maverick, or is viewed to some extent as upsetting the competitive equilibrium, and the following acquisition of that company was likely to be less intense competition in the market. So that's the second principal theorem, and I'll give you some examples later on from a case just to hopefully enable you to understand the theory more clearly. Third theory is a vertical effect. Now, in my stylized example, we have a producer of apples with a 45% market share for production of apples in Belgium. It is being acquired by or acquiring one of the leading supermarket chains in Belgium, which has, in my stylized example, a 50% share of the grocery retail market in Belgium. There's no horizontal overlap between the apple producer and the grocery retailer, but there is a vertical relationship between them. And there are two potential vertical effects. One is what's called customer foreclosure. So this is the possibility that customers, so in this case, customers of the 45% apple producer, might be foreclosed. So following the merger, if the 45% apple producer were to cease supplying apples to the remaining grocery chains, they could potentially be harmed because they would have reduced supply of apples, and that could have an anti-competitive effect. And the other vertical effect potentially is input foreclosure, and there the concern is that the input here, the apples that are being sold by the 25, the 15, and the 15% producers, they wouldn't be able to supply Carrefour anymore. Carrefour would buy only from its own apple producer, having been vertically integrated, and therefore the smaller producers would suffer because they would lose access to the biggest outlet. So those are the two main foreclosure effects that a vertical transaction might have. I'll explain in a second the type of evidence that is looked at to determine whether a vertical merger might raise concern or not. The final theory concerns conglomerate mergers. So this is transaction involving suppliers, companies operating in neighboring markets. In this case, we have an apple producer and a banana producer that are getting together. And there, the issues are similar to those that I talked about with respect to vertical effects. There's the concern that these producers might foreclose their rivals, other apple producers or other banana producers. And because in each case, in this rather stylized example, the apple producer is dominant, the banana producer is dominant, the supermarket, the grocery retailers have to buy product from them. The concern is that they will bundle their offering together or condition this on the retailer agreeing to buy bananas. And as a result, the smaller apple producers, the smaller banana producers will find it less easy to sell their products, and competition could suffer as a result. So those are the theories of harm, and the agencies will look at the available evidence to determine whether any of those theories of harm are plausible in any particular case. So before I look at the types of evidence that gets looked at, let me introduce you to some of the principles that have been developed for the use of evidence and concerning the burden of proof and the standard of proof. So merger control, as I mentioned, is a predictive exercise. They will rarely, if ever, be direct evidence of the competitive effect of a concentration. And what the Commission has to do is to reach a view based on an objective assessment of qualitative and quantitative evidence concerning current and future competition. And the merger regulation is silent on the evidentiary principles that apply in merger control. The courts, however, have developed clear evidentiary principles. And I said earlier on, the courts have played an important role across a whole range of areas, including the burden and standard of proof. The principles that the courts have developed are as follows. Firstly, there's no general presumption in favor of or against mergers. Second, the burden rests on the Commission to determine that a merger should be prohibited or approved. So there are two parts to that. Firstly, the Commission bears the burden. And secondly, that burden is symmetrical. If the Commission prohibits, it has to discharge it. And if it approves a merger, it has to discharge it. Both types of decision can be approved, and therefore the Commission has to discharge its burden to the requisite standard in both cases. Now, in three situations, the burden exceptionally rests on the merging parties. Firstly, if the parties advance a proposition or an argument that rests on evidence for which they can be expected to have, but they don't adduce it, then the Commission may reject the argument advanced. So essentially, if the parties are advancing a particular argument, they bear the burden of evidencing that argument. Now, it may entail the Commission to engage in some investigation of its own, but if, for example, the parties maintain that the counterfactual is a technical term that essentially means the but-for world. So what would the world like but for the merger? If the party's argument is that but for the merger, they would not have competed with each other, they have to adduce evidence as best they can that they had no intention to compete with each other. If they argue that, let's say, company Z was planning to enter the market, the Commission then has to investigate that to reach that determination, and the Commission bears the burden in respect to whatever determination it reaches in that respect. Second presumption concerns market shares above 50%, and there the courts have held that the Commission may presume dominance in respect of market shares above 50%, and the further above 50% you go, the stronger the presumption, and the merging parties bear the burdens of rebutting that presumption. There are all sorts of cases where parties have successfully rebutted that presumption, but the burden effectively rests on them to do so. And the third exception to the rule that the Commission bears the burden, which is to some extent related to the first, concerns the defences that exist under the merger regulation. So you may recall I said earlier on there's a great debate as to whether the Commission should accept political or industrial or employment considerations or take account of them in approving a deal, whether it should allow the creation of national champions, say, even where a transaction may cause competitive harm. And the Commission has rejected suggestion that it should take account of those considerations. There are, though, small subset of cases where the Commission may approve transactions that it finds would be anti-competitive. And the first is where it determines that the efficiencies that a transaction is projected to give rise to outweigh any anti-competitive effects. And there the merging companies have the burden of quantifying those efficiencies and proving that they will be passed on to consumers and proving in effect that they will outweigh any adverse effect. And the second area where the parties bear the burden is what's called the failing firm defense. And this is related to what I described a second ago, the counterfactual. So what would the world look like in the absence of the merger? If in the absence of the merger, the company being acquired would disappear from the market and therefore no longer exert whatever competitive pressure it exerts today, that company may be considered to be a failing firm. And in that circumstance, the Commission may determine that it's not the merger that reduces competition. Competition was going to be reduced in any event by the disappearance of the failing firm. But that's a pretty high bar that is set, but nonetheless one that the parties have to bear themselves. They have to show that the firm that they say would have gone out of business would in fact have gone out of business. They have to show that they have endeavored to find alternative buyers, and they have to show that any of those alternative buyers would have been no less anti-competitive than the merging companies. So it's a pretty high burden to bear. The basic principle, as I say, is that the Commission bears the burden of proof. Now, the more interesting debate is less around the burden, which is fairly established, but around the standard. For many years, there was uncertainty as to the applicable standard of proof. A former president of First Instance, Court of First Instance, now the General Court, and a leading jurist in our field, Bo Vesterdorf, he suggested that it was something more than balance of probabilities, but something less than beyond reasonable doubt. So as everyone I'm sure knows, balance of probabilities is the civil standard, the beyond reasonable doubt is the criminal standard. And Sir Christopher Bellamy, also a judge at the First Instance, agreed. He said the standard of proof lay somewhere between the two. And in a series of judgments going back to Tetra Laval, which is now, if you recall, about 15 years old, the courts have explored the question as to whether there's a balance of probabilities standard or a beyond reasonable doubt standard. Balance of probabilities test was the appropriate standard. The Commission must therefore predict the outcome that is most likely to ensue. And there's some debate, which I don't think are shown in the slides, raised by the Telefonica O2 case that I mentioned as one of the cases where a Commission prohibition decision had been overturned. Here, where the court appeared to depart from the Impala balance of probability standard in favor of a higher standard. So there, this is a prohibition case, and the court saying the Commission has to produce sufficient evidence to demonstrate with a strong probability. So a number of commentators, I think rightly, have suggested this raises the standards that the Commission must meet from a balance of probabilities to strong probability is viewed as being somewhat higher. My own view is that it actually matters less what the standard is. Probably the most significant question is the quality of evidence that has to be adduced. And there the court has been very clear that the Commission has to rigorously analyze a sufficiently cogent and consistent body of evidence. So the evidence has to be cogent, has to be consistent, has to be convincing, has to be compelling, a lot of C words, in order to meet the standard. So let's abstract from all of this. Burden is borne by the Commission. Burden is borne whether it approves or whether it prohibits. The standard is most probably a balance of probabilities, possibly something a little higher, particularly when it prohibits. The evidence has to be perhaps the standard is a bit higher in that respect. That's what the court is saying in 302. But certainly when it prohibits, and also I think at least the law says when it approves, the evidence has to be cogent, it has to be compelling, has to be consistent. Fundamentally, though, cases where the Commission, on a balance of probabilities standard, cannot adduce cogent, compelling, consistent evidence, then it has to approve the transaction. So let's look at the use of evidence. In the Deutsche Börse New York Stock Exchange Euronext case, which is a case I was involved in, the European Commission held that there's no hierarchy between different types of evidence. The court found that empirical analysis is often useful, but it's not essential. That was relevant in the case because we had said in the administrative stage, and it was argued on appeal, that the Commission did not adduce any quantitative, any empirical evidence to substantiate its case. The court said the Commission doesn't have to adduce quantitative evidence. Of course, if it has quantitative evidence, that's good and that's helpful, but it's not essential. Complex inferences can be validated or rejected by sophisticated empirical analyses, provided the necessary data are available. But if the data are not available, and in that case, the Commission said it simply didn't have the data available to conduct the analysis we said it ought to do, then the Commission didn't have to rely on that particular kind of evidence. So the Commission has a degree of latitude as to what kind of evidence it relies on. And one of the things that I think about when I'm thinking about a new case, in particular for a client, is to try to identify as early as possible what I think the critical areas of factual inquiry are going to be. And they will vary from case to case. And the examples I give in a minute will be illustrative of the different sorts of issues that arise. What do I think the critical issue or issues are going to be, whether it's market definition, whether it's barriers to entry, whether it's the competitive relationship between the merging parties, whether it's the role of innovation. And what are the pieces of evidence that I think are going to be dispositive of that question? And if you can identify early what the critical issues are, identify early what the critical pieces of evidence are likely to be, build a case early that addresses the issues with compelling evidence, and present that case to the Commission at as early a stage as you can, you're likely to maximize your chances of securing approval in a challenging transaction. If by contrast, and there's a whole spectrum of things here, you fail to identify what the issues are and or fail to identify and anticipate the types of evidence that might be useful or relevant or probative of those issues, then you may make it much harder for yourself to avoid a long investigation, to address potential concerns. And essentially the core of what we as practitioners do in this area of the law is try to predict the types of issues that will arise and try to predict the types of evidence that will be relevant. The Commission reviews and evaluates evidence from various different sources. This is not a comprehensive menu of the different types of evidence, but it's an introduction to them. So the first maybe, so I'm going to go top left along the first row and then the second row from left to right. So the first set of questions that one often looks at concern the characteristics of products and the substitutability of products from a consumer perspective. So do consumers view different kind of products as being in the same competitive set? So in this example, which is soft drinks, are colas viewed as being different in light of their prices and their characteristics and their uses to fizzy orange or to fizzy water? And there may be a lot of different kinds of evidence that may bear on that question. But the first set of questions you often look at, the issue in a case, is the characteristics of the products from the demand perspective, from a consumer perspective, and then from a supplier perspective. So you define your market, and then you look at your market shares. And there may be lots of questions that arise when you look at market shares. You look at value shares or volume shares. You take account of captive production. How do you define the market geographically? Do you take account of companies or producers that are not yet in the market? Supposing there's been some disturbance to the market situation the previous year, or there's predicted to be some change in the next year, how do you factor in those sorts of considerations? Third thing that you might look at is the structure of the market and the difference between the competitive position of the principal players on that market. Not just their market shares, but the strength of their brands, whether they've got products that are being developed, the competitive relationship between the merging companies and their rivals. To the second row, you then try to understand as best you can the competitive landscape. And a core part of what we as practitioners do in this area of the law is try to learn from business people who live and breathe markets, learn as much as we can in as short a period as we can how a particular market functions. And it's by understanding how a market functions that we can hopefully identify what the competitive effect of a given transaction might or might not be. And how a market functions has a whole variety of different aspects. And you learn to try to identify as quickly as you can what are the most important competitive features. Is brand name important? Is innovation important? Is an installed base important? Is access to production important? And it's by doing that that you're able, as I say, to get a better understanding as to what the effect might be. Now, third parties can play an important view. What are your customers or your competitors going to say about a merger? And you'll hear in the third session in a couple of weeks' time, one of the things that the Commission does when it's analysing a merger is to ask competitors and customers what they think about a deal. And while competitor views are important, they're rarely dispositive because competitors may have their own agenda for not being supportive or enthusiastic about a merger of their rivals, irrespective of whether it raises competition problems. But if your customers don't like a deal, then the agencies are much less likely to like that deal too. The Commission and you might look at independent analyses or independent experts' reports. They may be pre-existing reports that can be really quite useful, quite informative of particular issues, and I'll give you an example in a second. There are a number of economic firms and economic consultancies that have set themselves up or set up over the past 20, 30 years. Miguel de la Mano works for one of them, Compass Lexicon. You'll be hearing from him next week, and they provide economic support to lawyers in cases, particularly with respect to the development of empirical evidence. And I'll give some examples of what I mean by empirical evidence in a second. Two main changes in practice over the time I've been working in respect to evidence gathering and assessment, the increased importance attached to quantitative economic evidence and the increased importance attached to internal documents. And whereas in the early days, the Commission didn't have regard very much to internal documents, it didn't require that they be produced. Increasingly, the Commission is requesting and requiring the submission of very large numbers of internal documents. In case our firms are involved in at the moment, the Commission has requested, I think, 4 million pages of internal documents that it's going to review with forensic tools. Commission will also look at the likelihood of entry and of exit in a particular case. And then finally, the Commission will just listen to experts' views, whether they be market participants or whether they be other industry experts in any particular case. So you have at your disposal a vast array of different types of evidence as a lawyer, and you have to try to determine what's likely to be particularly important. In some cases, and I'll give you an example of a case where there was one piece of evidence that was dispositive, but in very many cases, it will be a range of different types of evidence that will be probative. So let's start with market share data. Market share data, to some extent, are the easiest data to gather. And although they're no substitute for a comprehensive analysis of the competitive dynamics, they are the starting point of the Commission's analysis. And as we've heard, high market shares create a strong presumption of dominance, while low shares below 25% create a presumption that concerns won't arise. Very often there's a big debate as to how do you define the market. Markets have both a product dimension. So the example I gave you, do cola-flavored beverages compete with orange-flavored beverages? But they also have a geographic dimension. Do colas sold in Belgium compete with colas sold in France or not? And bottoming out those questions will be important to determine what market shares are probative in a particular case. Define a market too broadly and the market shares won't tell you very much. Likewise, define a market too narrowly and they may exaggerate the competition concern. So the Commission will also look at the increment resulting from the merger. So if the combined share after a merger is 40%, that's more likely to be a problem if the merging companies each have 20% than if one company has 38% and the other has 2%, because the competition, the significance of the competition that's being lost is far reduced in the 38 plus 2% than in the 20 plus 20. So the Commission looks at the increment. We'll also look at the gap between the merging party shares and those of their competitors. If the gap is sizable, so if you, let's say, have a 40% share and then a fragmented market with 10 players, each with a 6% share, then it's more likely that the 40% company is going to be in a position to raise prices because each of its rivals is too small to constrain it. If by contrast, the 40% company has a rival with a 30% share and then rivals with 20 and 15 and 10 and so forth, that's more likely to constrain them. Commission will also look at the strength of rivals and the strength of customers. Sometimes customers may exert such bargaining power that they are able to overcome any market power that the merging companies may have as a result of the deal. The focus of review in recent years, the last decade or so, in unilateral effects cases has been on the competitive dynamics between the parties. What competition will be lost? And in trying to determine what competition will be lost, agencies or the Commission inevitably looks at the nature of the competition in the past. If companies were competing intensively with each other in the past, then that competitive interaction, which will inexorably go as a result of the merger, will assume greater significance. So market share data and issues relating to market share data will be important. Commission will also look at customer and competitor testimony. Commission's historically attached importance to competitors' views, particularly when certain sorts of questions arise, but may be skeptical of competitor complaints because they may just be more concerned that competition is going to increase. I have a case at the moment where one of the complainants essentially says what it's concerned about is the fact that pricing has been going down over time, and it's concerned prices will continue to fall after the merger, which is not a very strong competition concern. Where the Commission pays greater concern is where customers are concerned. So in this case, just one of many large proportion of responding customers voice concerns about the reduction of choice post-transaction. Customers fear the reduction of choice will be followed by deterioration of product quality, reduced service levels, and ultimately also price increases. And the Commission will be reluctant to second guess the views of customers, since it will take a view, perhaps understandably, that the customers will know the business best, and if they're concerned that a merger may reduce competition, who are they to take a different view? As I said, empirical evidence is extremely important. Economic evidence, data. So here I have 5 examples, and I'll give you some more detailed examples in a second. So the first one, Tetralaval, the quantitative data in that case was trying to determine whether different products were in the same market. And the data concerned a correlation of prices of different products, elasticity data to determine how elastic demand for one company's products was to changes in price in another party's products. In the second case, bidding studies were used. So bidding studies are relevant to determine competitive interaction between merging companies to see to what extent in a market where companies bid for a particular opportunity, if the merging companies face one another often, then they will be viewed more likely as close competitors, and the competition that will be lost by the transaction may be greater than if the merging companies are relatively infrequently in competition with each other. In the third case, the Oracle PeopleSoft case, the Commission looked at merger simulation models to determine whether the merging parties would be able to raise prices post-transaction. So Miguel can tell you more about these sorts of models next week, but it is possible by looking at past evidence of price changes and levels of concentration to simulate what the effect of a particular merger might be. In the fourth case, and I'll give you another example in a second, this involves a coordinated effects case. So one of those cases where you're concerned about tacit collusion between a relatively small number of players in a concentrated market. And there the Commission looked at pricing data to see the extent to which the principal suppliers in this particular market, this was iron ore market, where their prices were similar, whether they were moving in parallel, because where you have prices that are similar and move in parallel and can be observed, it's more likely that tacit collusion may take place. And in the final example, and I'll give you an example in a second, this was a vertical effects case. And you recall when I talked about vertical effects, the concern there was foreclosure. Did the merging companies have an incentive to foreclose inputs or foreclose customers? And question there is whether there is an incentive. Now, you can measure incentives using empirical data. What the data tries to measure is to weigh the benefits of a foreclosure strategy against the costs of a foreclosure strategy. If I favor myself, I may get a benefit that you can quantify, but it will come at a cost because you won't be supplying somebody else, so you will forego some degree of sales. And trying to weigh those up empirically is something that economists can help with. Some further examples of quantitative data being important. Again, bidding data and statistical analysis in the GE Alstom case, in the Ryanair Aer Lingus case, which involved air transportation. Commission engaged in a price study to determine the competitive constraint that Ryanair and Aer Lingus imposed on each other. In the Campina foods case, Freshland Foods case, the Commission tried to determine whether the parties' dairy products were close substitutes, and they used scanner data to try to measure the elasticity of demand for the company's products. And in the Philips, the ConocoPhillips Statoil case, which concerned retail sale of petroleum products, Commission used an econometric analysis to measure the extent to which one company's service station had constrained the prices at another company's service stations. Now, there's some practical implications of using empirical data. It's important as a lawyer. I mean, there are lots of things that's important as a lawyer to understand. You need to understand the law, obviously. You need to understand how companies operate. You need to understand the politics sometimes of companies, and you need to understand how to use and to work with economists. And the questions I often ask myself when I'm working with economists, is there a need to engage an economist? Can an economist add value? If so, in what way? What substantive issues may be informed by an economist? Economists are wonderful people. They're very curious. They're always hungry to do work. But what realistically can be done? And that's also a function of the availability of the data and the cost of that data. If data aren't available or are available at very high cost or are not particularly robust, then it may not make sense to spend a lot of time, effort, and money engaging in a particular analytical exercise. So fundamentally, we ask what economic evidence is likely to generate sufficiently robust data to be probative of the issues under investigation. And to do that, you have to understand the methodologies that the economists are going to employ, the assumptions that are likely to be made, and to play devil's advocate. So you try to predict challenges that may be made in respect of particular kinds of data and preempt those challenges so as to maximize the chances that empirical work that you present will be accepted and will compel the conclusion that you want it to. Fundamentally, you're engaging in a cost-benefit exercise. How expensive is this likely to be, and how much benefit is it likely to have? So when we think about the work in any case, the low-hanging fruit is commission precedent that I referred to earlier. That's your first port of call. Some market share data that may give you a quick and easy screen. Does it look like the shares are high? Does it look like the parties are important competitors? There may be some market research that's out there. There may be some independent reports of some kind or another that are out there. And then you have to decide, does it make sense to get an economist involved with every everything that entails? Are they going to be able to generate evidence that's useful? And what are the documents showing? Is becoming extremely important. As a former Deputy Assistant Attorney General, Department of Justice, a former partner of mine, Dev Gelfand, said company documents are extremely important to our analysis, and they offer merging parties an excellent opportunity to convince us why their view of the world is correct, and we need a complete picture. And here's some examples of cases. You can see steadily increasing number of internal documents that the Commission is requiring. Now, internal documents have been required in large numbers for many, many years by the US agencies, but it's a relatively recent phenomenon of the European Commission requiring such large numbers of documents. To answer a question, some of you may be asking, how can the Commission possibly read all of these documents? But they don't read them all individually. They have computer tools, like we have computer tools that will do searches, use keywords. They'll try to narrow these 2 million documents into those that they think are most probative. And in so doing, of course, they have to try to avoid cherry picking, try to be fair, to ask questions in cases of uncertainty as best they can. When you file your notification, and you'll hear in due course that the notification form is called Form CO, you have to provide some documents already. So papers that have gone to the board analyzing the transaction, already analyses of the market over the last 2 years. But it's not routine to provide extensive documents, but the Commission in challenging cases will increasingly request those documents. And why does it do so? Why does it view documents as being critical? Because they provide an agency with a quick and easy indication of how companies view the transaction. Bad documents may lead to a prolonged investigation and form the basis of a complaint. And good documents, for example, documents demonstrating a merger results in efficiencies or user benefits, can facilitate approval or address a particular complaint. One of the difficulties that we have as counsel is that it's very often to replicate the depth and breadth of a document review when you're trying to advise a company whether a transaction is likely to succeed. So I have a case at the moment where we're advising a company on a particular transaction. One of the interesting areas of our practice, which I've not mentioned actually, but I will do now, concerns the evaluation of risk. What do I mean by that? Well, when companies are negotiating a transaction, the allocation of risk arising from the need to secure merger approval can be an important part of that negotiation. A buyer in an ideal world will not want to assume any risk. It will want the possibility to agree to buy a target for 100 euro, let's say, only in the event that it gets approval. If it doesn't get approval, it can walk away. The company that's being acquired or is being sold, the owner of the company that's being sold or the target that's being acquired, will not want to find itself in that situation. It won't want to find itself in the situation where it's spent 1.5 years defending a merger control process only to find the transaction dies and it walks away with nothing. And so we're often employed not only to advise a board as to whether we think a deal will be approved and on what terms, but that may then feed into the allocation of risk provisions in a contractual document, a transaction agreement. Does the buyer take the risk? Does the seller? How does risk get allocated? What obligations does the buyer have to get approval at any price? What responsibilities does the seller have to assist in that approval? So, that by way of background, I'm advising a client at the moment on whether to buy a particular target. They'd like to buy the target. There are a number of other companies interested in buying the target. The seller of this business has said, we're not taking any risk, so you have to agree, for sake of argument, that you will pay us 100 euro, 100 million is more like it, or $1 billion in this case, irrespective of whether we get approval. If you don't get approval, then you have to sell your overlapping business in order to get that approval. So you're bearing all of the risks. Now, the critical issue in this case is whether the target company was a potential competitor in one particular area of business. And we're trying to reach a judgment on that issue without full access to the facts. We don't have access to the business people in the target. We don't have access to their internal documents. If the internal documents are very unhelpful, that increases significantly the risk of an antitrust issue arising when the agencies get to review the documents and review the transaction, and in turn should make the company less ready to assume the antitrust risk. I say that both to emphasize the importance that documents can play, and also just to explain how knowledge of the antitrust process and the way in which transactions may be assessed can feed through more broadly into legal practice. And there's increasingly sort of close relationship between M&A lawyers and competition lawyers within law firms, as the competition law part of deals has become more and more important. When I first started work, securing antitrust approval was almost an afterthought for most deals. Now it will be something that companies try to evaluate very early on, an important part of their decision whether to proceed with a deal. So, enough introduction on the evidentiary principles and the types of evidence. Let's move now to some case studies. So I've got about 10, I think. I'll go through them. They each illustrate the way in which different kinds of evidence can be probative, and also, I think, help to explain the different sorts of issues that routinely arise in merger control. They're all cases I've been involved in to a greater or lesser extent, so I know a bit about, so if you have questions, you can ask me. So the first case, which is a relatively recent case, involves the combination, the proposed merger of two supermarket chains in the UK, Sainsbury's and Asda. And if you look at the top left, you see the leading supermarket chain in UK is Tesco, followed by Sainsbury's, followed by Asda, and then the fourth chain is Morrison's. And this transaction, which was a blockbuster deal in the UK, was reviewed by the UK authorities for, I can't remember, well over a year, was viewed as being something of a test for the UK authorities in a post-Brexit world, raised a wide variety of different sorts of issues. So first set of issues concerned the geographic market for retailing. If you look at the bottom left visual, that shows the distribution of Sainsbury's and Asda stores. And it was a couple of questions, quite important questions, whether competition took place at a local level. So if you look at the local market picture just next door, so that's a particular region of the country, and it's showing the number of supermarkets in there. You can imagine a incredible amount of empirical work would have gone into building those visuals for all of the different areas of the country. Essentially, economics will tell you that in geographic areas where the merging parties are two among a relatively small number of players, you should be more concerned about the loss of competition than in others. There was also a question as to whether, in addition to local market competition, there was competition at the national level. So that was a whole separate set of inquiry. There was then inquiries relating to whether competition took place principally between the big four, or whether they were also in competition, and if so, to what extent, with two specialist or smaller retail chains, Waitrose and Marks and Spencer's in the UK, and Co-op in Iceland, and two sets of discounters, Aldi and Lidl, and the competitive interaction between the big four and some of the smaller players. A third set of issues that was examined was the extent to which bricks and mortar retailers were constrained by home delivery chains, Amazon and Ocado being the principal ones in the UK. So whole range of issues that were looked at, considerable amount of empirical data. Two main theories of harm investigated. Could the transaction result in higher prices, lower quality, reduced range, or reduced innovation? Unilateral effects as a result of the loss of competition between Sainsbury's and Asda, either locally or nationally. And secondly, was there a risk of tacit collusion, so coordination between the leading groups? Ultimately, the competition authority identified so many local markets where it had competition concerns that the party decided not to proceed with the transaction. So let me turn now to my second case, and just by way of aside, one of the things that I enjoy a lot about this area of practice is just the opportunity to learn about so many different markets. So we've gone from retail, grocery, sale in the UK to PVC, which is kind of plastic production. This is a case where geographic market definition was central to the Commission's assessment of the merger of two producers of PVC, and curling. This was because the geographic market was defined to comprise the UK and the Nordic region. The merchant companies would have accounted for around 80% of sales. But if the relevant geographic market was the entire EA, then the combined share of the parties was around 25%. Now, market share is just a proxy, really, for determining the competitive environment in which a merger takes place, but it's probative and clearly important. What's more important, really, is what's going on beneath the market shares and the evidence that's relevant to assessing what the right, in this case, geographic market is. So in this case, the Commission concluded the market was wider than the UK and the Nordic region, at least as wide as Northwest Europe. And it did so by looking at a number of different pieces of evidence. Firstly, it looked at whether prices were correlated in different parts of Europe. And if you have a correlation, you have a relationship, a positive relationship between pricing in different regions or between different products, those products are more likely to be competitive with each other. Because if prices go up in one country and that's followed by prices going up in the other country, that suggests they're subject to the same competitive pressures. Secondly, PVC was easily transported and there were significant trade flows. Thirdly, the majority of customers said the market was regional or wider. And many UK customers, notwithstanding the fact that merchant companies accounted for something like 80% of UK sales, but they said they sourced part of their needs from continental suppliers. And this was a function of the fact that barriers to expansion by continental suppliers were low. So it'd be interesting to see whether the same result would arise today, given the trade barriers that have arisen as a result of Brexit. But perhaps the most important piece of evidence, and this is instructive as to the need to be creative sometimes in cases, related to an historic event that had occurred some years previously. Some years previously, the INEOS plants in the UK had suffered an outage, so they'd gone down. So what had happened? Supply had gone down. Now, if the UK were its own market and demand had remained constant, faced with a reduction in supply, you would expect prices to go up because supply following the outage would be too low to meet demand. What you in fact saw, though, that prices didn't move very much because there's a question about the audio being interrupted. I hope the audio is not being interrupted, but if it is, I'm not sure I can do very much about it.
Sometimes it is.
Sometimes it is. All right. Well,
yes,
sorry.
maybe
Yeah.
it's good that it's the reason why I cut off my video. So it's maybe better if people try to close their video for the rest of the session before the break to see if that works.
Okay. Yeah, that could reduce the bandwidth indeed.
Yes, thank you. We'll try. Thank you.
We'll try. Very good. Sorry about that.
No worries.
So there was the outage, prices remained constant, and what do you conclude from that? You conclude that the UK was part of a broader geographic market. Me also, okay, well, I hope it's still better. Recorded that the UK was part of the same geographic market as other countries in Europe, because the shortfall in supply in the UK was being met by a product flowing into the UK from abroad. So a good example of empirical evidence being probative of a critical factual issue in the case. Let me go to my next example. This case involved two companies that produced financial data, in this case, earnings estimates data. And this is a good and early example of a case where companies' internal documents can be probative of a particular issue. What the Commission was looking at was whether the transaction would raise horizontal concerns in the market for earnings estimates data. And they looked at the parties' business planning documents, and what those documents showed was that the parties viewed each other as their closest competitors. In one document, it says, in estimates, only Reuters and Thomson are best in class and highly competitors in its market, but Reuters has surpassed them in many other areas. No other company is comparable offering to either Thomson or Reuters for historical estimates. Now, if you knew what the document showed at an early point in the transaction, in reviewing the transaction, then you might already anticipate that that could be a concern. The market share data alone might not have indicated that there was a concern. This case involved toilet paper. In this case, toilet paper sold in the United Kingdom. It involved the combination of two brands, the Andrex and the Kleenex brand. And their combined share was around 45%, I think. So somewhat at the borderline of the kind of shares that have historically raised competition concerns. And there was a lot of work done to try to show the competitive relationship between the brands and so forth. But perhaps the most influential piece of evidence was a pre-existing market study that was authored by one of the merging companies' agencies, advertising agency. And what that report said, that brands are important in the UK, and there were only really two important UK tissue brands, Kleenex and Andrex. These two brands compete directly. Other UK brands are poorly advertised and exhibit weak brand loyalty. So on the basis of that document, together with other evidence, the Commission concerned that a combination of these two businesses would take out an important competitive dynamic from the market. The next case concerns the Deutsche Börse NYSE Euronext case, transaction I mentioned earlier on that went to the European courts. You recall the court judgment on the hierarchy of evidence that may be used in a particular case. Now, the core of that case concerned two derivatives exchanges. One exchange operated by New York Stock Exchange in London called Life, and another exchange operated by Deutsche Börse in Frankfurt called Eurex. And they each traded interest rate derivatives, which are kind of financial instruments. So if you looked at the European market for interest rate derivatives traded on exchanges, the transaction would be a merger to monopoly. There were only two real exchanges in Europe that traded interest rate derivatives. But the interest rate derivatives that were traded on Life were different from the interest rate derivatives traded on Eurex. Life traded short-term interest rate derivatives. So if you want to hedge against a short-term change in interest rates, you might buy a short-term interest rate derivative. And Eurex traded long-term interest rate derivatives. And so we argued that the trading of short-term and long-term interest rate derivatives were distinct markets, that in respect of the trading of each of those types of derivatives, we each competed with a different third party. So Life competed with CME, the Chicago Mercantile Exchange, and Eurex competed with the Chicago Board of Trade. And interestingly, the US agencies have allowed those two exchanges to merge, in part because they were persuaded by a similar kind of argument to the one that we were running, although the US agencies subsequently took a view that they rather wished they hadn't approved the deal. But anyway, they did approve that combination. We said you should approve our deal as well, because, and these two charts make that clear. The left-hand chart is the trading on Life. It shows that the principal competition is with the CME, and you see the correlation between the Life and the CME trading prices, even though the Life derivative is expressed in euros and the CME derivative expressed in dollars. You see a same correlation with respect to the Eurex in respect of long-term interest rate derivatives. However, the Commission, third parties, customers were very concerned about this merger, and the Commission relied in large part on internal documents that said, among other things, Eurex and Life are the only two relevant players between which every game in this space is decided. And the Commission identified evidence each exchange contemplating competing with the other exchange, trying to lure customers away from the other exchanges, taking account of the way in which the other exchanges priced their products, and was concerned, given how concentrated the market already was, by the loss of competition between the merging companies. The two exchanges are locked in constant competition right across their businesses, including product development, technology fees, and incentive schemes and service values. So that was a citation from one of the company's internal documents, which was obviously unhelpful to the parties, but supported the Commission's case. So this is the case that I mentioned earlier. This is, you recall, the Austrian case, the 4-3 transaction, giving rise to a post-transaction share of around 27%. Here again, internal documents were important in this case because they emphasized the role that the target company was likely to play in a competition as a result of the transaction, and predicted price increases. So this, you recall, the Siemens-Alstom case. This involved producers of trains. Remember, this is a transaction that gets prohibited and causes some political outcry on the part of the French and German governments, which challenged the combination to the European producers of trains, the European trade control system of units. The Commission used bidding data for competitive tenders to show the closeness of competition between the parties for the onboard units. And what the bidding data showed was the merging parties participated in the majority of contested tenders. Alstom was the most frequent bidder, followed by Siemens. The merging parties were each other's most frequent rivals, and of contested tenders lost by one merging party, the vast majority were won by the other merging party. So that was pretty strong empirical evidence that the parties were competing closely with each other. So you remember the coordinated effects cases that I talked about, and the coordinated effects theory. The coordinated effects theory, as you recall, holds in a market which is relatively concentrated, where products are relatively homogeneous, so similar to each other, and where prices are transparent. And the theory of harm is that as a result of the concentration that reduces the number of players, there is a greater risk of tacit collusion. So companies operating, the remaining players operating as if they were in a cartel. So they can observe changes in their rivals' prices and follow them, thereby reducing competition. So that was the theory of harm that was analyzed in this case. This is the Sony BMG case, which involved the recorded music industry. And the two slides I'm going to show you, a lot of these slides I've taken in effect from either commission decisions or presentations I've made from one or other audience. These two slides we actually presented at an oral hearing. We presented to then Commissioner Monti at a closed door meeting with him. And the theory in this case, as I say, was a coordinated effects case theory. So that theory was as a result of the merger, in this case, there were 5 record companies. 2 of them were merging, so after the transaction, there would be 4. The Commission tested the theory that this was a market that was already subject to coordinated effects. The companies were already acting in parallel. And we said that was not the case for a number of reasons. Firstly, this market was not susceptible to tacit collusion. It's not homogeneous. There's insufficient transparency and so forth. But we also said there's no evidence of parallel pricing. And the Commission had gathered literally millions of items of data, not only from the merging companies, from their main rivals, in order to test whether pricing levels had been, whether the company's prices of recorded music have been moving in a parallel. So we simulated what you would expect to see if prices have been moving in parallel. And this slide does that. And what this slide shows for companies A, B, C, D, and E is that their prices move in parallel. You can see if one goes up, everyone else follows. One goes down, everyone else follows. So the correlation is very close to 1. Perfectly correlated products, the correlation is 1. Imperfectly correlated products, the average correlation is much lower. And also the gap between the highest and the lowest is fairly small. So they can, their prices are in a fairly narrow band. And we said, if this were a market where tacit coordination were already taking place, this is what you would expect to see. But in fact, on the basis of your own data, this is what you in fact see. So you see much bigger spread between the higher and lower prices. You see an absence of correlation. Sometimes one company's prices go down, nobody else follows. Other times someone goes up, nobody else follows. And there's no systematic company that's the highest price company or customer that's the lowest price customer. And this empirical evidence was probative in showing that the market, at least then, was not subject to coordinated effects. If a market isn't already subject to coordinated effects, it's a higher burden. It's harder for the Commission to show that it's likely to suffer from coordinated effects in the future. The next case study I'm going to give, this concerns a vertical transaction in the avionics area. And the question the Commission looked at is whether the merging companies would have the ability and incentive to restrict the supply of engine controls. So that's the upstream product produced by Goodrich. In this case, Goodrich is being bought by UTC. UTC is a downstream producer of jet engines for regional and corporate aircraft, and it competes with Honeywell, and it competes with Williams International. So the question was, post-transaction, would Honeywell and Williams International continue to have access to Goodrich engine controls? And the Commission relied in part on the customer views that Williams was dependent upon Goodrich because it would have difficulty switching to another supplier, and that Goodrich would be willing to risk its reputation by disrupting supply to favor UTC. So the views of customers here were important in shaping the Commission's assessment of a factual inquiry. Was there a risk of post-transaction foreclosure arising from Goodrich's merger with UTC? The next two cases, there will be the final ones before we're then going to have another break for the last two slides, two sessions. This concerns conglomerate effects, a combination of producers of frames and sunglasses with a producer of lenses. And there the questions was, is there a risk of foreclosure, as there always is in these kinds of conglomerate cases involving products with companies on adjoining markets. The question that arose in respect of frames is whether, as a result of the transaction, there was a risk of foreclosure through the tying of Luxottica frames and Essilor lenses. And would that foreclose other producers of lenses? And the Commission determined that the market shares were too modest to allow effective bundling of frames and lenses. And there was no indication that Luxottica had market power with respect to frames, that its frames were a must-have product, so foreclosure could be excluded with respect to frames. And as to sunglasses, the Commission surveyed third parties. There the question was a risk, the ability to foreclose by tying Luxottica sunglasses and Essilor frames. And the third party questionnaire showed only 15% of opticians and 18% of retail chains thought Luxottica sunglasses were essential. And only 7% of opticians thought they'd lose lens revenues if they lost access to Luxottica sunglasses. And there was a practice of multi-sourcing. So the risk of foreclosure was deemed to be small, and therefore the transaction was approved. A conglomerate transaction, though, that was challenged, this concerned General Electric's acquisition of Honeywell. And General Electric produced jet engines, and Honeywell produced avionics that were sold along with jet engines to producers of aircraft. In addition to producing jet engines, General Electric was also the largest lender of finance, lender of money to the aircraft producers. So if you were an aircraft company, if you were a purchaser of aircraft and you wanted to borrow money to buy an aircraft, you would go to General Electric's leasing arm, GCAS, and borrow money. And the theory of harm was that GCAS had in the past conditioned its finance on the aircraft purchaser insisting that the aircraft it produced had a General Electric engine installed in it, and that this had harmed General Electric's rival producers of engines because they were unable to be installed in aircraft that GCAS provided funding for. And the concern was post-transaction that GCAS would pursue the same course of conduct with respect to Honeywell avionics, and that would harm Honeywell's avionics rivals. They would find themselves unable to be installed in aircraft bought by companies that got finance from GCAS. And the commission maintained this theory of harm. It was quite controversial at the time. And one of the reasons it did was documentary evidence from General Electric's then CEO, Jack Welch, effectively saying that they did use GCAS strategically in order to support General Electric's other businesses. So these then, I realize, have been a lot to take in, a lot of different examples of cases in which evidence has been important and evidence has been used. This, as I say, is really the core of what we as antitrust lawyers do. So we're going to take another pause, I say another 10 minutes. Why don't we come back at 10 minutes before the hour? And then I'm then going to cover jurisdictional issues and the division of power between the European Commission and the member states. So let's take 10 minutes break and then we'll come back. Hello, hello. So welcome back. Can everyone hear me? Better, I hope.
Yes, we hear you very well.
All right. Very good, very good. So 2 down, 2 to go, but we will be brisker on these two. Incidentally, if anyone wants to ask any question about any of the slides that are being covered so far, now's not a bad time.
Well, hello. Maybe one short question, bearing the risk that you've already mentioned it, but it was maybe cut out by the audio. You mentioned previously when considering if you should hire or engage in activity with an economist, that you should also bear in mind what it would cost to get an opinion. Could you maybe give us just a rough number of what you should averagely calculate with the costs for an economist? I mean, keeping in mind that you will not be able to give a broad answer, but maybe a from to range or just a over the thumb estimate.
That's a really hard question. I mean, the cute response would be too much. The second sort of cute response would be, I should say this with Miguel Tilamano being present, would be 2 or 3 times more than you think. But let me try to help. I'm not going to give you a direct answer because the question in a sense is too broad. An awful lot will turn on exactly the nature of the economic work or the economic support that you get. And when I think about engaging economists, there's a spectrum of work that I might engage an economist for. So at perhaps its simplest, it could be to have an economist just to brainstorm with, to review my submissions, my briefs, to identify weaknesses, play devil's advocate, identify work possibly, but ultimately it doesn't really come to very much. Put together some market share maybe because some of the information is a bit confidential from each party. Let's say, for sake of argument, the cost of that might be, I don't know, 50,000 euro, let's say, for a case. At the other end of the spectrum, okay, you have a case that goes on for a year and a half and is reviewed by 20, 25 agencies around the world. You have to engage in, do you remember the supermarket example I gave where we looked at competition at the local level? You had those isochrones, those local markets, which had to effectively be put together with data that existed, but had to be tailored for a particular, for the particular case. That sort of exercise can cost many millions, to be honest, in order to do that, particularly when spread over a long period of time and a lot of different geographies. And then there's a very large number of different situations in between. So I think a better way to think of this, if I might say, because economists, like lawyers, broadly speaking, charge for there's a relationship between the amount of time they spend and the amount that they charge. There's not a perfect relationship. There may be other things at play, but broadly speaking, that's the way economists charge. It's probably better to think of it as the costs incurred with particular kinds of work in particular sorts of situations. And they will be a function of how readily available the data are, whether you're covering a range, a large number of different jurisdictions. If you want to get, I mean, there's economists and there's economists. So we generally work with firms of economic consultants. They have differences, but like law firms, they do broadly the same thing. Sometimes, though, you may want to engage kind of a superstar economist, and there are some superstar economists around the world, to write a paper that will say whatever I mean, paper won't necessarily say what you want it to say, but to address a particular topic. And then if you are trying to get one of the great economists of the world, then you will pay inevitably more. That will be more expensive than getting some other economists, just one of the run-of-the-mill economists to do the work. The reason I was making the point was less about trying to nickel and dime a particular process, because I know these sums of money, particularly to students, will sound like very large sums of money. Doing significant transformative deals is expensive. It takes up a lot of senior management time. It can tie up an awful lot of resource. The bankers can be very expensive. Lawyers can be expensive. And getting top-rate economic support can be critical, but it can be expensive. Really, the point I was emphasizing in this is not necessarily to obsess about the cost, but just to think carefully about how to use economists and what kind of economic work is most valuable. And this is not a criticism of economists. They're generally, I mean, I love working with economists. They're extremely creative. Sometimes, though, it bears testing the value of a particular work stream, the likelihood that the data exists. You may need to understand the assumptions on which particular kinds of empirical work rest, and the likelihood that in light of maybe shortcomings in the data, assumptions that are maybe questionable, together with a uncertainty as to whether the inquiry in question is likely to be helpful, you may conclude that the probative value of this exercise is just not worth it, whether it's 50 or 100 or 200 or whatever it is. The two slides I showed you from the Sony BMG case, the first of those slides cost €250 to generate, because that was about the cost at the time of an hour of time of an economist. He and I sat in a room and I drew it and he put it on a computer and it looked good. The cost of gathering all of the data for the commission did and we had to do to produce the second slide, what you actually observe in the market, the cost of that would have been several million probably. Because you couldn't just do that one slide. You had to, the commission chose to do 5 countries over many years with millions of items of data and so forth.
No, I mean, thanks for that very detailed explanation. But I think it's absolutely fair to say that you sometimes, if you know about what amounts we are talking, you will probably definitely think twice if you really need a highly paid economist to gather some data, or if a research assistant will do the same work as on a fraction of the cost. Of course.
Now, sometimes being candid, the economist will be better value for some areas of work than the lawyers will be, or they will be indispensable. So, for example, you're trying to construct bidding data. It's very sensitive data. And so companies can't exchange it between themselves. So you need some third party to gather it. Or you want, I've alluded a couple of times to the role that advocacy plays in this area of practice. And since we're chatting and since I'll do anything to delay talking about the jurisdictional scope of the merger regulation, and I think it's a bit more interesting, I'll just talk about, say a word or two if people are interested about the different sorts of advocacy that we engage in. So one of the first types of advocacy we engage in is explaining to our clients this process. So what they should expect, what they should be prepared for in terms of duration, in terms of cost, in terms of how draining it's going to be of their time, what the likely outcomes are going to be. Should they think about potential buyers of assets they might have to divest? what advisors should they get. So there's an advocacy role, and that will differ us between, let's say, a general counsel who may have been through this before and be quite sophisticated, and a board who's coming to this for the first time. Then we may play an advocacy role with lawyers from the counterparty. So we're advising a company that's trying to buy another company. We're in buy mode, they're in sell mode, but we have to persuade them to do a deal with us. We have to persuade them we have a strategy to get this deal through. And that's a different sort of advocacy. Then we have advocacy before the agency, and that's kind of the principal advocacy in the sense of engaging. And it has a written form which can be incredibly time-consuming. Building a brief, developing a notification can take months. There's somewhat of an art to it. There's a lot that's not. There's a lot of just presentation of facts and of data. Where I think there's a bit more of an art is in the visual advocacy. So in the reduction of often what are complicated facts and a complicated story into accessible slides that show something, that show, as you've seen in this Sony BMG case, price correlation data or whatever it is. And those, the time I find I spend a lot of time preparing slides for meetings with officials, which often don't last that long, maybe 2 or 3 hours, but you're trying to reduce or synthesize what are often very complicated, noisy facts going in all sorts of directions into compelling graphics that stay with your audience. And then in due course, as I mentioned, some cases go on to appeal, and then before a court, court advocacy is somewhat different than advocacy before an administrative authority.
Well, thanks a lot for that. Very detailed and very pinpointed information. I think it was great. It was exactly what I was expecting.
Super. Has anyone else got any question?
Yeah. Hi, Nicholas. It's Sonia here. My experience is in a competition law in Australia and also the Middle East, and we don't have the practice of the regulator being asking for internal documents in a merger context. So I'm just wondering, how important has it become in compliance programs to school clients about being careful about the internal documents they produce, or is that just impossible?
So that's a good question. So internal documents, as I've said, have definitely become more important, although I recognize that at least 2 of the case studies I gave where internal documents were important are actually quite old cases. So it's not as if the commission's just suddenly stumbled onto internal documents as being important. What's changed, I think, is just the sheer number of internal documents that they request, and therefore the difficulty in anticipating what all of those documents are going to show. Because to go to the last question, I mean, there's a cost element in an awful lot of what we do, and companies are understandably perhaps loath to set teams of lawyers loose in reviewing hundreds of thousands of documents just on the off chance that they might find helpful or unhelpful documents. So we often get sight of kind of the key documents, the board papers or other reports or assessments. But what it's harder to get sight of is all the things that are in the background. I realize your question was not about that. It's about compliance training. So compliance training in general has existed for some considerable length of time. We give compliance training to clients, and yes, schooling them on document preparation has become a more important part of that. And what I sometimes do, if I'm given the chance and given the budget, is to try to simulate documents that either we found in a company's records or I've seen with other clients, but obviously change the names and change the formats and so on, to sensitize business people to language, how to express your points that are unhelpful to a use and so forth. However much schooling you give, it's extremely difficult to reach everyone. And secondly, sometimes people are corresponding on perfectly legitimate topics in a perfectly legitimate way without any transaction in anticipation, saying things like, God, competition is fierce out there. We as lawyers would say, it's great you're saying that. We just lost a really important deal to B, without any expectation that a year or two later they'll be trying to buy B. And it's almost impossible, and I'm not even sure it's really desirable to school business people never to exchange any written communication within a business about the competitive environment, because they can't do business in that basis.
Great, thank you.
Any other questions? Sonia, you should probably take off your screen because we're, I thought I saw one hand up, but I didn't want to.
Yes, thank you very much. Very quick one maybe, but it was mentioned several times in cases that customer survey was conducted, asking customers. This is a very important part of assessment, but this is very also costly. And whether my question is whether there are any thresholds or any benchmarks, how many customers, what percentage of customers should be asked, or how to make it reliable to put into the case? Thank you.
So that's a great question. So firstly, there's no prescribed benchmark. The Commission doesn't limit itself in any way. Second observation before I go back to the first question, the Commission generally does two things. It will send out questionnaires, and it will probably cast its net fairly broadly, and then it may conduct interviews with some customers. Now, markets vary. So to take one of the markets we looked at, the supply of avionics and engines to producers of jet aircraft, there are only like 3 or 4 customers. So getting 3 or 4 customer responses, you've basically covered the market. There are other markets, to take an extreme example, consumer product markets, where you've got literally everyone. So let's take the Cola Pepsi example I gave in the market definition. You've got 50 million in any country customers. So therefore, in that sort of market, well, the direct customers are the retailers, but when you're trying to test consumer substitution, then you might want to test consumers, and then they might run a consumer survey in order to test that. But it is often a subject of some critical debate in a case. So I have a case at the moment. We just filed a submission yesterday, actually, in that case. And my client and the company we're buying, together they have around 6,000 customers in this particular market. And the antitrust authority had sent out questionnaires to 500 of them. And it had gotten responses from 45 of them. Sorry, it had chased 120. It had gotten responses from 45, of which 12 had concerns. And so, and of the remaining, so the 12 is, let's say, 25%. And of the remaining, they were divided between those who were positive about the deal, those who were neutral, and those who didn't respond to the question. And so the authority in their brief to us said the largest number of customers who expressed a view were concerned about the deal, right? Now, mathematically, that's true. 12 is more than the other three, let's say, for sake of argument, were each 8. But it's totally misleading, because 12 customers being concerned out of whatever it was, 4,000, or even 12 out of 500, or even 12 out of 45, on any of those figures, it's small. So there's no, I mean, that just happens to be fresh in my mind. I think, you know, there's a kind of truism here in a way that for any survey to be of probative value, it has to be sufficiently robust in its scope and in the quality of the responses. One of the other areas where you often find yourself disagreeing with the agency is the way in which it's asked questions. So there is an art to how you ask questions, and you should ask questions in a neutral way, and you shouldn't lead in your questions, and the way you position potential answers in a multiple choice question can be important.
Sorry, was it interrupted only on my end?
No, I see it too. Just a second, I will see. Where is Nick gone?
I think he's gone now.
He's gone for me also.
Yeah. Let's wait. Okay.
But I have the impression that it's his internet, which is a little bit unstable, because I also see that those 4 little pillars that are next to the window, they are sometimes yellow and red. So probably indicating that his connection is a bit bad.
Yeah, I think he will reconnect. So let's wait 5 minutes and he will probably be back at that time. Apologize, really sorry for that. I see Nicholas is joining us. Can I ask you, everyone, to stop the video? Maybe because I think he's in Rome and the connection is not very good over there. Apologies. And let's see our next slide. Okay. Okay, so Nick is trying to reconnect. I'm really sorry. He should be there in a few minutes. Again, apologies. Okay, everyone. So Nick confirmed that he had to reboot his computer. He doesn't understand why, but he will be back in 5 minutes for sure. So please meet again at 5:26 in Brussels time. He is apologizing again. Really sorry for this. I hope it will work after that. So thank you. Thank you for your understanding. Hey Nick, is it working now?
Hello, I hope so.
Yes. So I shared the slides. So if you want, I can move the slides through, so it doesn't take too much of your connection as well. Or do you prefer? What do you prefer?
I'm well, I don't exactly know what happened, but
Me neither.
I can let
Okay.
me.
Yeah, I have to. Wait, I have to make you co-host. Yes.
No, I'm okay. I'm going to screen share now. So, okay, is that good? Can you see that?
Yes, it's good to see that.
All right, I'm really sorry, everybody. I hope you survived and everything. Does anyone have any more questions, or shall we move to jurisdictional scope?
Yes, go ahead.
Let's move to jurisdictional scope. Let's not test our luck too much. So we've got two more decks. Maybe Sonia, you should blank your screen. So since we have a bandwidth issue, maybe. Anyway, so jurisdictional scope and then division of powers, they're kind of connected. So when the merger regulation, as I said, was being drafted and prepared, there were a broad variety of issues that were considered at the time. And one important one, particularly for the member states, was the jurisdictional scope, because it delineated EU jurisdiction from national jurisdiction. And although at the time few member states had functioning systems of merger control, I think they anticipated that they might in due course have them, and a sizable number of them already did. And since, as you've heard, there's a mandatory reporting requirement, the European Commission has exclusive jurisdiction over transactions that fall within its remit. It was a sensitive question as to where you drew the line as between EU jurisdiction and national jurisdiction. And there was also a debate as to what kind of transactions did you capture. Clearly, you would capture acquisitions of 100% control. And then there's a sliding scale, a spectrum that goes all the way down from de jure control to de facto control to maybe non-controlling minority shareholdings. And so one of the areas of debate was how to define the rules. And for the first few years of the merger regulations practiced, a lot of time and effort was spent figuring out whether a transaction fell within the scope of the merger regulation or didn't. And you may recall one of the early pies I had when I showed those 50 cases where the Commission reached a decision it didn't have jurisdiction. Those cases all date from those early days when we were learning how to define some of the provisions of the merger regulation. So this is an area of practice which is now fairly well established. It's one of the reasons I'm going to go through it relatively briefly. And then when we're done with jurisdictional scope, I'm going to talk about the division of powers. So the mechanisms that exist to allow jurisdiction to be allocated as between the member states and the European Commission, notwithstanding the fact that when you apply the thresholds, it falls for European review or for national review. And actually this has been a rather dry area of practice, but has become a rather more interesting one over the last year because of a guidance paper that the Commission came out with in March of last year, which sought to address one of the issues that I teed up earlier on, namely, is merger control fit for purpose? Is it able to capture all transactions that can potentially raise concern, particularly what's called killer acquisitions? So these are acquisitions of small companies that may in time become significantly more important ones. So let's rattle through jurisdictional scope first, and then we'll do division of powers. So I'm going to talk about the scope of application of the merger regulation, the definition of a concentration, mergers, acquisitions of different types of control and joint ventures, the definition of EU dimension. So EU dimension is the term of art that's used to capture the revenue thresholds that must be met in order for a transaction to be reportable. These rules are fairly well laid out in the text of the merger regulation and in the consolidated jurisdictional notice, which codifies the Commission's practice with respect to defining the jurisdictional scope of its rules. So, when you're looking at a transaction, you ask yourself a number of questions. Is the transaction a concentration? So is the form of transaction one over which the Commission has jurisdiction? Who are the undertakings concerned? Undertakings concerned is a term of art used to define the entities whose turnovers you take account of when deciding whether the thresholds are met. Are the worldwide, the EU-wide, and the member state turnovers? What are the turnovers of the undertakings concerned? If, once you've allocated turnover globally, EU-wide, and on a member state basis to the companies you decide are the undertakings concerned, do you have an EU dimension because the thresholds are met? And if you do, you have a reporting requirement in Brussels. And if you don't, are there referral mechanisms? That's the division of powers deck that I'll turn to in a second. So the topics, and I'm not going to go slavishly through every slide here because the principles are fairly well established and we can read about them in the consolidated jurisdictional notice. But let's turn to concentrations. So the rules capture acquisitions of control or decisive influence. And three distinct types of concentrations can be identified. Firstly, mergers. Secondly, acquisitions that fall short of mergers or are different from mergers. And thirdly, what's called full function joint ventures. And transactions that don't confer control may nonetheless be subject to Article 101 or may be subject to national merger controls. I gave the example of Germany and the UK. Someone rightly pointed out Austria. And there are other jurisdictions within the EU where non-controlling minority shareholdings may be subject to reporting obligations. So here you see a spectrum going from a majority shareholding on one end of the spectrum to a minority shareholding without veto rights on the other end of the spectrum. And majority shareholding is reportable, a majority of voting rights acquisition is reportable, a board majority is reportable, the acquisition of veto or blocking rights on strategic issues may be reportable, but the acquisition, an acquisition of a shareholding that gives only material influence but not decisive influence won't be reportable, and nor will the the exercise of an option right or a minority shareholding without veto rights. So as I say, acquisitions of control are invariably reportable. Control will be highly fact specific. Control is defined broadly. So acquisitions of 50% of a shareholding base will invariably be reportable. But also if a company has, in effect, veto rights that over strategic decisions, it gives rise to de facto control, they will typically be reportable too. So let's talk about mergers, the simplest kind of transactions where two companies merge to form a single new company, to are absorbed into each other. They will be caught by the merger regulation. Acquisition of control, as I say, control is the possibility to exercise decisive influence. Control may be acquired de jure, so as a matter of law, or de facto, and control may be acquired solely or jointly. So acquisitions of sole control, one company acquires another, or an interest in another, or jointly, two companies acquire joint control over a third company or set up a joint venture. And a lot of the dialogue about the scope of application of the merger regulation concern the question of control, sole control or joint control. So de jure sole control arises in three situations. Company owns more than 50% of the shares. A minority shareholding has preferential shares that enables it to dictate the commercial strategy, or where a company has veto rights over decisions on matters of fundamental influence. So that gives rise to negative de jure sole control. And de facto sole control, this you don't have control as a matter of law, but you might have as a matter of fact. This is generally where a minority shareholding in fact enables you to exercise control. You don't have any legal right, but you have, for example, your shareholding is sufficient to give you a majority of votes cast at shareholders' meetings, or you have links with other shareholders that mean, in effect, they're likely to allow you to exercise control. Here's an example of a 27.5% shareholding that was found sufficient to confer sole control. The transaction was ultimately prohibited, so the determination of control was an important question. The reason, the principal reason, was because the 27% shareholding translated into a more than 50% share of votes cast at recent shareholder meetings. The next largest shareholder had only a 3% shareholding, and the owner of the 27.5% shareholding was the only industrial mining company that had a significant shareholding in the target, and therefore the other shareholders in practice deferred to that company. There's another example in the deck that I won't go into. Acquisitions of sole control, therefore, are reasonably easy to identify the circumstances when they arise. The other situation, as I say, is acquisitions of joint control. And that is typically where two companies exercise decisive influence over a third company, company C in this example. And they agree either to jointly acquire company C or they set up company C as a standalone joint venture that they jointly control. By joint control, it means they each have to, in effect, agree matters of significance: appointment of senior management, approval of the business plan and budget, and investment strategy. And there's an example here of a case of two companies that were found to exercise joint control over another. Second example here. Changes in the quality of control can be reportable. So you can have a situation where joint control exists and then one of the shareholders withdraws and the remaining shareholder buys the other one out. So that's a change from a joint to sole control, and that will be reportable provided the thresholds are met. As I mentioned, the creation of a standalone full function joint venture may be reportable. It's not just the joint acquisition of an existing company. Two companies may decide to enter a market with a joint venture, and that will be reportable if it meets certain requirements. It needs to be autonomous, operationally independent, and functionally independent, and it needs to be long-lasting. What does that mean? It means it needs its own management, and it can't be unduly dependent upon its parents. So it must have sufficient assets to be full function, typically, and it may vary from industry to industry, R&D, production, distribution, and sales. So a production-only joint venture will not fall under the merger regulation, may fall under 101, may be reportable at the national level, but a full function joint venture, in my example, Sony Ericsson set up a joint venture active in R&D, production, and distribution. That's reportable, but Sony and Sharp have just a joint production venture which produces for each of them. That's not within the scope of the merger regulation. It must be operational independence, and it must be long-lasting. Now, just a word or two about some of the mechanisms that have been introduced to try to avoid companies circumventing the merger regulation. Merger regulations has provisions to ensure that transactions that are entered into at the same time and are interrelated are treated as a single concentration. And this is to avoid companies having, let's say, one transaction to set up a production joint venture and another to set up a distribution joint venture. And they say, well, since neither one of them is full function, neither has to be reported. And the Commission says, no, you have to look through that. Transactions that are clearly interrelated and are linked by mutual conditionality, they have to be seen as being part of the same transaction. The second example is one where, let's go back a slide, is one where two companies enter into successive transactions over a period of time, and the Commission is concerned, or the architects of the merger regulation were concerned, that companies might try to avoid jurisdiction by, let's say, company A agrees to buy one business from company B that is below the threshold, a second business 6 months later below the threshold, a third business 6 months later below the threshold, and therefore avoids jurisdiction in respect of any of them. The Commission says, no, if you have within a 2-year period 2 or more transactions between the same parties, then you must look at, then you essentially keep adding up the turnover of the businesses you are requiring. And as and when the thresholds are met, the Commission has jurisdiction not only over the last deal that triggers the filing requirement, but also over the previous ones. So you cannot escape jurisdiction. Sometimes companies have tried to avoid jurisdiction by structuring deals to park a business with another company in order to close it and avoid the prohibition on closing transactions prior to getting approval. It's called warehousing, and the Commission has looked through those deals, and in this case, Toshiba Medical Canon, they fined Toshiba because they determined that they'd effectively partially implemented the transaction prior to having gotten approval. Second set of issues that arise concern the calculation of a turnover and the identification of the undertaking concerned for purposes of a turnover allocation. So I'm going through these slides quickly because they're really fairly self-explanatory. You're not going to get tested on them. And if you need the answers to any question that arises about how to determine who the undertakings concerned are, how to allocate turnover, the answers you can pretty much find in the consolidated jurisdictional notice. Questions sometimes arise over the geographic allocation of turnover. That can be important because the merger regulation thresholds have two levels, and the second level of them looks at turnover at a member state level. So sometimes determining whether the member state thresholds are met can be important to determining whether the Commission has jurisdiction. So that is what I wanted to say on this topic. I'm going to stop screen sharing for a second, open up the second slide deck that I was going to show, which is on the division of powers. And then I shall move to this topic. So, I say, okay, can you see that? Everyone or anyone?
Not yet, it's coming.
It's coming. Can you see it?
Same here. It says it's loading.
Yes.
It's loading. I'm very sorry for the technology today. It must be extremely frustrating for you guys.
It's okay.
Hang on a minute. Let me try.
Yeah.
Does that work?
Yes, now it's working.
Yes.
Okay, great. Right, let's get going on the division of powers. So when the merger regulation was enacted, as I said, there was a debate over the division of powers, the jurisdiction the Commission would have and the jurisdiction that the member states would have. And the merger regulation had a number of core principles. Firstly, the idea of a one-stop shop. So the Commission would have exclusive jurisdiction over transactions that had an EU dimension because the thresholds were met. Secondly, as a result of that, member states may not apply national merger controls to concentrations that fall under the merger regulation. Correspondingly, third principle, the EU has, the EC has no jurisdiction to over transactions that fall under the member state rules. And by way of exception, though, the member states agencies may transfer cases from the national level to Brussels, or they may request that Brussels transfers cases to the national level. And then a final principle is that exceptionally national agencies may review transactions on non-competition grounds, which I sneak in just a few slides on that at the end. It's a pretty rare occurrence. So let's talk about case referral. So there's a notice that explains how these principles work. Essentially, there are two sets of rules that go in each direction. So there's and four types of case referral. So there's the possibility in this example for a case that's reportable at the European Commission level to be reviewed, in this case, by the Irish authority. And this may occur in two ways. The Irish authority may ask the Commission to refer a case from Brussels to Dublin because it thinks it's better suited, or the parties to a transaction may ask for jurisdiction to move from Brussels to Dublin. In no case is the Commission obliged to let jurisdiction pass. The Commission has discretion. It generally takes the view that the agency which is best placed to review a transaction will review it. And those two mechanisms operate in the other direction, by which I mean there's a possibility for the Irish authority in this example to refer a transaction to the European Commission to review. And there's a possibility for companies that find themselves subject to Irish jurisdiction to ask for jurisdiction to be transferred. And here are the statistics. So the first two columns relate to cases that are referred from Brussels to the national competition authorities, either, and that's the first column because the national authority asks, or, and that's the second column, because the parties to the deal ask for jurisdiction to be transferred. And the second pair, the third and fourth columns, relate to the other situation, referrals going in the opposite direction from the national authority to Brussels. And you see there are far more cases going the other way. And the reason is because companies often find themselves in the situation of being subject of not meeting the Brussels thresholds, but being subject to review in a number of member states. And they think it's more efficient for for Brussels to review and for there to be a single review rather than myriad national reviews. And then there's a smaller number of cases where the national authorities may decide of their own volition to refer a case to the European Commission. And it's in regard to that case, so the third column is Article 22 possibility that the Commission has issued a guidance paper that I've now referred to a couple of times in March of last year. And what that guidance paper does, and it's proven to be more controversial maybe than the Commission thought, is it encourages member states to refer transactions to Brussels that don't meet the member state thresholds. Why did the Commission do that? The Commission did it because it wanted to ensure that these acquisitions, these killer acquisitions, as they termed it, largely in the digital or the pharma sectors that didn't meet the EU thresholds, maybe didn't even meet the national thresholds, there was nonetheless some kind of residual way to make sure they were being reviewed. And so the Commission encouraged national authorities, if they came across a deal that they thought was a problem deal, to refer the deal to Brussels. And so I'll talk a little about that in a second. But the majority of cases have been cases where merging parties have asked for jurisdiction to be transferred from Brussels transferred from the member state level to Brussels. So let's just talk a little about these. So these are referrals. So first I'm going to deal with referrals from the Commission to member states. And this can happen at the request of a member state or the request of the parties. I won't go through the details of the modalities of it. You can read the slides and see the process you have to go through. But the situations where a referral to a member state may take place are largely ones where the member state either considers itself and therefore asks for a referral, or the national or the parties take a view that the member state is better placed to consider the transaction because the markets are largely national. This is a beer case that went to the Irish authority because the Irish authority was better placed to review the transaction. This is a case, the next example is one in building materials. These are national, largely local markets, which went to the UK authority to review national or local markets. It's not only that the Commission takes the view that the national authority is better placed, but also because if a concern exists, the Commission's jurisdiction is limited to largely really to concerns that affect a substantial part of the common market. And if you have a very localized concern, there's a debate as to whether the Commission is really in a position to address that concern regarding regulation. This is an example of a case where national authorities were used as being better placed to examine the richness of our area of practice. You look at all sorts of markets. This concerns the slaughtering of pigs, the production of pork and pork products, which the Polish authority requested a referral because they thought it was better placed to review the transaction. In some cases, though, the Commission rejects referral requests. In a series of cases involving the telecom sector, the Commission has been a bit concerned that national authorities might approve deals that it has concerns about, and has therefore have been reluctant to accede to referral requests. So the other set of referrals are referrals to the Commission from the member states. Again, these may occur in two ways: under Article 22 at the request of the member state, or under Article 4.5 at the request of the parties. Google DoubleClick was a case we were involved in, where we actually asked for jurisdiction to switch from the national authorities to the Commission, because we thought the Commission was better placed to examine the deal rather than have 5 member states review the transaction. It made more sense for one agency that had quite a lot of experience in looking at matters relating to Google, which it did. As I said, sometimes the member states request. This is an example where the member states requested a referral to Brussels, a transaction that would otherwise have been reviewed by many member states, and they took a view that it made more sense to have a single review in Brussels. Here's an example where one member state asked Brussels to review, and the other member states that could have reviewed the deal joined that application, so there was a single review. This is the Commission's new referral policy that I mentioned a moment ago. This was the Commission's response to criticisms that potentially significant deals were escaping review at either the national level or at the Commission level. So the Commission published a guidance paper last year encouraging member states to apply this provision of the merger regulation to transactions that don't meet national merger thresholds. The original intention of this provision of the regulation was to allow just that, member states that didn't have merger control rules to refer transactions. So someone's raised their hand. Go ahead, please ask a question.
Yeah, thanks for giving me the word. If anyone is interested in a recent case, I can tell you about Illumina Grail, where just that is the issue, that the case was referred to the European Commission, while the parties argue that there had been no jurisdiction in the national NCAs and also not at the European Commission, but but it was referred to the European Commission, which then took up the case because it said, okay, now that it has been referred, it's in our jurisdiction.
Exactly. So you should be doing this presentation next year. Exactly. This is the slide that talks about that case. But so I will get to this case in a second. Just to go back a bit, so the Commission introduced this policy in March 2021. The rationale was to ensure that acquisitions of nascent competitors by dominant incumbents in particular in the digital and pharma areas, did not escape review. And the guidance paper has a number of relatively novel features. So it introduces some uncertainty as to whether a given transaction may be reviewed in the EU. Until the guidance paper was introduced, most advisors, I think, would have said, if you don't meet the national thresholds or the EU thresholds, then it's very unlikely to end up in Brussels. The policy doesn't require that the target generate any revenues in the EU. So in the Illumina Grail case, one of the points the companies make is that the target has no EU business at all, but nonetheless has been caught. It's sometimes not straightforward to determine when the referral risk has expired. Why is that important? Because we're talking about transactions that may actually have closed, and the guidance paper specifically allows member states to refer transactions that have closed to the European Commission. Generally, transactions that have closed can't be reviewed if the thresholds aren't met. So this policy has been quite controversial. Some of the member states have been critical of it. They weren't consulted on it, at least specifically before its adoption. The Federal Cartel Office, a very influential agency in Europe, finds it troublesome from a legal perspective for the EC to establish jurisdiction where it is not the case. And some business organizations have also been critical of it. So the Illumina Grail case, to date, it's the only case where the guidance paper has been employed. In fact, the Commission asked the NCAs to make this referral before they adopted the guidance paper in February of last year. Concentration didn't meet any national thresholds as Grail had no EU sales. France accepted the invitation, although there was some litigation before the French courts that Illumina lost, joined by Belgium, Greece, Iceland, Netherlands, and Norway. The Commission opened an in-depth investigation, and in a fairly aggressive move, Illumina actually completed the transaction while the investigation was ongoing, but is keeping Grail as a separate and independent unit. The Commission has adopted interim measures suspending the implementation of the transaction, and it has opened an investigation into Illumina's potential violation of the standstill obligation. Meanwhile, Illumina had appealed the Commission's decision to accept jurisdiction. So this is a case. It's become like sort of the bleak house of court disputes. So there's now this case is being looked at on several fronts. The Illumina has appealed the Commission's acceptance of jurisdiction to the European courts. So there's appeal of that decision. The Commission has opened an in-depth investigation, and I think issued a statement of objections now into the transaction, so it's challenging it substantively. And the Commission has also opened an investigation on the suspected procedural violation, because it's a slightly grey area actually whether Illumina was entitled to close the transaction in circumstances where they say they weren't even subject to Commission jurisdiction in the first place. So there's a lot of action in respect to this area of the law. What's going to be interesting, obviously, is to see how all this litigation unfolds and ends up, and then to see whether member states are going to start referring transactions to the Commission that don't even meet their own thresholds. So what was a reasonably settled area of the law has become a little less settled, a little less certain. I think one way to think about it is one manifestation of what is quite an exciting febrile time in merger control, with a lot of different views being expressed. And this just tracks back to a theme that I've mentioned now a couple of times. Is the consumer welfare standard the right standard to apply? Should one take account of industrial policy considerations and therefore permit transactions that are anti-competitive or could be anti-competitive, but create European and national champions? Should you take account of environmental considerations and employment considerations? Has enforcement been too permissive? Should the Commission intervene more, as more national authorities are doing? And the UK, the Germans, the Australians have established a kind of informal alliance of international agencies that believe enforcement should be tightened, that the Commission has been too lax in enforcement, that challenging only 30 deals in 30 years is insufficient. Then there's the debate over the digital sector in particular. Are the rules fit for purpose? Are the jurisdictional thresholds correct? How do you capture killer acquisitions, these acquisitions of small incubators, companies by the digital platforms? What are the mechanisms to stop them becoming even stronger? And there's then in parallel, which I don't have time to talk about, and it isn't really within scope, but is within scope as in the sense it's what we as lawyers do. There's been a whole set of new regimes established to enable national governments to subject acquisitions of companies to foreign direct investment scrutiny, to screening regimes, to make sure acquisitions do not raise national security concerns. So extremely interesting time in our world. Let me first thank you for sticking with this. I apologize for the interruption and what seems to be not terribly smooth transmission at times. And then thirdly, to invite any further questions before we come to an end.
Yes. Hello, everyone. Is there any question still that you want to ask quickly? No. Well, I'm trying to open my video, but it doesn't work. Okay, there we go. Well, if there is no question, thank you very much, Nick, for this session. Really sorry for the technical problem. Yes, it's the technology that we use. Sometimes it works and sometimes we don't understand why. I suppose it's vacation still and everyone is on Netflix. Anyway, yes, Aga, you can ask a question. Okay. Well, don't worry. Have a good weekend, everyone. You can always send me an email that I will transfer to Nick if there is question. And we will see you on Friday, the 21st of January still again. So thank you and see you next Friday for the second session. Thank you very much. Have a good evening. Bye.
Thank you. Bye-bye.
Thank you. Bye-bye.
Thank you.